for consideration of my interim prayer, but due to paucity of time, it could not be taken up. Only, my lord, that a Supreme Court order on has to be placed. Lord, so I pray this matter can be taken up Monday, my lord, or Tuesday.
Prayer for listing, give it to the court master, please. Ask prayer for listing, give it to the court master.
Lordship, I have also got a similar pair for list tender matter pay for listing of.
Please give it to the court master.
May plead your lordship. Regarding item number 16, lordship, motion matter. I have filed one caveat, lordship, that may be called for lordship. Problem.
I'd like to mention item number 28 and 29, my lord.
Yes.
I'm the petitioner, my lord. A matter may be taken up after vacation, my lord.
This after vacation is paid for by land council with the petitioner. Okay.
Obvious. Yeah, please, lordship. I like to mention item number 27 and 42, my lord. We
20,
take it 27 and 42, my lord. Maybe taken after a week, my lord.
27.
Yes, my lord.
It goes after vacation.
Yes, my lord.
Okay. List after vacation is paid for by land council with the petitioner. Item 27.
Yes, my lord. And 42 also, my lord. 42 also.
42.
Yes, my lord.
Okay.
Obvious.
May it please the lordship, I beg to mention item number 43 and 44 of the daily list. The lordship, the other side has filed their affidavit. We need further time to file a reply, your lordship.
Okay. In order to obtain instructions and file affidavit in reply, the land council with the petitioner prays for adjournment. Prayer is allowed. List after ensuing vacation. 43, 44.
43 and 44.
Okay.
If your lordship pleases, lordship may fix a date.
I'm not fixing right now. I
Much
can mention after that.
May it please, Lord, for listing on Monday, my lord.
Give it to the court master.
I'd like to mention for upgradation of item number 50. Because considering the mercy petition.
Oh, acha. Okay. Okay. This will be upgraded and taken up. Item 50.
Obvious.
I hope you have instructions with you.
15, Malam,
50.
50. Malam. But they're seeking 1 week's time, extension of 1 week's time.
Then we have the vacations. We can't.
My lord, his condition is very serious in jail right now. Doctor give orders.
After a week, nothing. It will not be effective.
Can it be on Monday, my lord? Something.
You take it not before Monday. Monday then,
Monday, Malam.
because we can't adjourn this matter.
Yes.
Monday positive.
What sides are represented? Ms. S. Sharma, Leonard, government advocate, prays for a week's time to obtain instructions. Next paragraph. As this writ petition relates to prayer for mercy on the petitioner. Taking into account that after the next week, the court will be on vacation for summer vacation. Adjournment for a week is refused. This matter will be taken up on Monday, 26. We'll do one thing. We'll give you 1 day. We'll make it 27th.
My lord, 27, I will be out of discussion, my lord.
It's okay. Your presence may not be required.
26 may kindly, then I.
No, because she'll have no working day to get instructions.
Otherwise, it has to be fixed on 30.
Wednesday?
28 then.
No, sir, I will be out for 3 days, madam.
will be out of station.
Yeah, that's a 26, let's try.
She will not
It's
get
month.
instructions. Tomorrow is not a working day.
Yes.
So today she
They
will
can
communicate.
officially communicate these things.
Our governor doesn't run that way.
All right, then let it come on 30, madam.
Yes.
30
30,
30 will be Friday. This Friday.
26, 2023,
26.
30.
Deeply obliged.
Problem.
Daily list item number 1 for Udroel.
Okay. Both sides are duly represented on the prayer made by Mr. A. Ahmed, counsel for the petitioner. Seeks to withdraw this petition. Seeks to withdraw this petition. This one, prayer is allowed, matter stands dismissed on withdrawal.
I am
Yeah.
appearing for risk number 5, my lord.
Outside, all sides are represented.
Always.
Supplementary cause list item number 66 for Udroel.
You can withdraw it. Same order, AMHR Khan. AMHR Chaudhary for the petitioner.
Item number 2 for Moshal. Number 2.
Yes,
My lord, I am a Khatian holder in respect of one plot of land which belongs to Barpeta Satra. In the name is Pukhaibar Baha. And I have been illegally and forcibly evicted from that Khatian by Barpeta Satra committee. So I
this
filed a
writ
petition
petition
before.
would not be maintainable. You file a suit, whatever you do, but the writ petition would not be maintainable.
My lord, I have submitted one application for the landed deputy commissioner for registration of possession. That may be disposed, that may be disposed, my lord. In the, this way directed to dispose of that application.
Where is that
Annexure K,
petition?
Annexure K,
Page.
page 43. That deputy may be directed to dispose by this application.
Just 43.
Yes.
But Deputy Commissioner will have no jurisdiction to entertain this petition. You have to approach the civil court.
My lord, under 54A, there is a provision for registration of possession, my lord.
They will not be permitted to do it. You have Land Grabbing Act, you have the civil court.
Not
It will
land
not
grabbing,
be-
my lord.
They will not be able to do it.
My lord, not land grabbing, my lord. It's a matter of, I was a Khatian holder under Barpeta Satra. And Barpeta Satra committee evicted me without any lawful decree against me. And 54A of the Temporary Settled Area Act, my lord. Serial page number 669 of that book.
Six 669.
Yes. Fifty-four A, my lord, restriction of possession. In my application, although I have not reported the provisions, I am a layman, my lord. Just I filed the petition stating that I have been
So, but
evicted.
now you file an appropriate application.
My lord, at that time, I had not considered any advocate, my lord.
It's okay. Now you file an appropriate application. Close it with liberty to you to move an appropriate application.
My lord,
Heard Mr. H.L. Moria and counsel for the petitioner and Mrs. S. Sharma, learned government advocate appearing for
Respondent number 2, my lord.
respondent number 2, and Ms. G. Hazarika, learned Shani Counsel for the Revenue Department appearing for respondent number 1. Next panel. The case projected by the petitioner is that his predecessor in interest were the Rayat of Pukhuri Paror Bahar, Pukhuri Paror Bahar, Baha. And the name of the petitioner is entered into in the Rayati Khatian in respect of the said land. Full stop. It is projected that the respondent numbers 3 to 5 have evicted the petitioner without a lawful decree of eviction. Full stop. It is also projected that against such eviction, an application dated 18/8/2022 was filed before the district magistrate cum deputy commissioner, Barpeta district, but no action has been taken. Next paragraph. The this writ petition under Article 226 of the Constitution of India. Next paragraph. The learned counsel for the petitioner has submitted that the petitioner, being a layman, had inadvertently left out to mention in the representation dated 18/8/2022 that the district magistrate cum deputy commissioner would have jurisdiction to entertain such petition under section 54 capital A of the Assam within bracket temporary settled areas bracket close Tenancy Act 1971. Next paragraph. As essentially this writ is directed against the private respondents. In view of the existence of alternative and efficacious remedy before the Deputy Commissioner, Barpeta District, under section 54A of the said 1971 Act. The court is inclined to close this writ petition with liberty to the petitioner to file a fresh application before the Deputy Commissioner, Barpeta District, under section 54 capital A of the Assam within bracket temporary settled areas Tenancy Act 1971, along with a certified copy of this order, and on receipt of the same, the Deputy Commissioner, Barpeta, within bracket respondent number 2. Shall register the proceeding and pass appropriate orders thereon with the appropriate observations and thereon in accordance with law. With such observations, with the appropriate observations, this revision stands closed.
Yeah.
May I please your lordship, my lord? All the petitioner, my lord,
Will be entitled to protection from eviction,
well, they have already evicted, my lord.
already evicted.
We filed an application for compensation, my lord, there is a provision, my lord. That was not done. So I filed a representation, my lord. And so that.
Okay, I'll issue a notice then.
Yes,
The only thing, my lord, if I may most humbly draw your lordship's attention to page 54 of your lordship's brief. They're right over the land, my lord. Bedokhali Zorimona,
Yes, my lord, we say that everybody.
they are encroachers
Yes, my lord.
at best.
One thing, my lord, Your Lordship,
No, that is okay. But still,
there is a judgment of division bench. my lord.
even an encroacher will have some right. Either you, what you call? Either you revoke Rule 18 or any other provision of law. But since prayer is limited to compensation, we'll issue a notice that the authorities decide.
My lord, if I may most humbly draw your lordship's attention to the prayer. Page 29,
Yes,
they want pattas,
so that is okay. You have seen the prayer Mr. Chaudhary is making.
my lord.
So far as prayer number A is concerned, can you show that the being an encroacher, he would not be entitled to this compensation? If you can satisfy the court that under Transparency Act, he is not entitled to compensation.
My lord, I'll obtain instructions whether at all this allegation would stand scrutiny, because in the event the government has not taken any step, my lord, then
My lord, as per my,
this,
we have.
this
we have
writ
the
cannot be
possession of
used
the
as an
land, my lord,
instrument to
because we say
force
that
the state.
Bahira Khasda, my lord.
Well,
I have stated, my lord,
it's okay.
Yes,
If he's raising an issue of maintainability, we'll put that into the order.
and there is a division bench order also, my lord.
It's okay.
Yes, my lord.
He's
Let
raising
notice
a-
be issued, my lord.
She's raising a question of maintainability, we'll hear it.
Yes, yes, my lord.
Had Mr. NNB Chaudhary, counsel for the petitioners, and Mrs. S. Sharma, and government advocate appearing for respondent
2,
number
3 and 4, my lord.
2, 3, and 4, and Mrs. G. Hazarika, and government advocate, standing counsel for revenue department appearing for respondent number 1. Keeping the issue of maintainability open, you should notice a motion returnable in 4 weeks. Requisite extra copies of the writ petition be served on the Learned State and Departmental Council in course of the day. Next paragraph. Pendency of the writ petition shall not be a bar for the respondent authorities to examine the claim of the petitioner insofar as claim for compensation is concerned.
Yes.
List after 4 weeks. We are keeping the issue of maintainability open.
My lord.
We can argue on the next date.
Or
May I please, Your Lordship? This matter is regarding cooperative election, my lord.
You give representation to everyone except the authority, who is the registrar. How can anybody else help you? Mr. Harudar,
Correct, ma'am.
for election, I think registrar is the authority.
Maybe directed to press.
But I fail to understand, you see, you are a counsel. Can you come to court for this period, take a liberty and go back when you can give a correct advice to your client then? Is it appropriate? To the conscience, is it appropriate? Then you're not doing it pro bono. Why you can't give correct advice? Why you don't read the only one book you have to read? You come to court, take an advice from the court and go back. It's not fair. The clients come to the lawyers and then that is why you see people have a tendency of saying that the lawyers, they doubt the credibility of the lawyers. For one man, the entire community is being ridiculed. But Mr.
H.A. Lashkar.
A.K.
H.A. Lashkar.
H.A. Laskar and counsel for the petitioner. And Mr. S.K. Tahudar, standing counsel for the Corporation Department. At the outset, the Learned Standing Counsel for the Corporation Department has submitted that this writ petition is misconceived as an election dispute, as the power to settle an election dispute is vested with the registrar of
Election
cooperative
authority.
societies. Being the election authority. Full stop. The court finds force in the submission of the learned standing counsel for the Corporation Department. Accordingly, this repetition stands closed with liberty to the petitioner to move the election authority as provided in a manner as provided under the Assam Cooperative Societies Act.
Election rules 2019.
Acha, Assam
Cooperative Societies election rules
election rules 2019.
2019.
Okay.
Please,
I
Yes. Do you seriously object to this prayer?
Yes, Lord.
Why?
Land Grabbing Act is not applicable in my case, Lord.
No, whatever that is not against this is imposition of
Can,
cost. Imposition of cost.
Imposition of cost is subsequently the final order was passed on 23/3/2023, Lordship.
So this repetition is directed basically against that.
Learned SDO passed promulgated our order under section 144 CRPC, Lordship, on 38th of October 2018.
No, you see, the challenge here is order dated 28/2 and 23/3.
Yes, Lordship.
Hmm.
There is no infirmity in the order.
Why?
Turn to Annexure 9, Lordship, page 38.
38.
Yes. Order dated 25/1/21, Lordship. The learned counsel for the respondent is present. The order arises out of a petition by number so and so filed by the respondent praying for vacating the ad interim injunctions order dated 26/4/19 and to direct the petitioner to file appropriate civil suit in appropriate court of law stating that the court-wide order dated so and so 26/4/19 and fixed 24/6/19 fixed 26/4/19 for filing formal petition by the petitioner under the Assam Land Grabbing Act, Lord.
Yes.
But they have not filed any land grabbing act at the time of when the order was passed, Lordship. Till 26/1/2019. Then, Lordship, page 44, Annexure 12. Next page, Lordship, 45.
Yes.
On going through the case record, it appears that since 4/3/21, for almost about 2 years, the petitioner side had taken various adjournment on this or that pretext, and it is only after the petitioner side was given large chance by order dated 3/1/21 that it submitted evidence on availability of this of 3 witnesses on the large date fixed on 19/1/23. However, even after they were allowed sufficient time to appear to face cross-examination against the petition number so and so has filed. Since 2021.
That is okay, but you see, page 46.
Yes, Lord.
The court denied to accept it because the prescription doesn't have a clinical note.
Prescription, then Lord, page 14 of this petition, Lordship.
So does a person have a control over how the doctor will write a prescription?
Because they have, there is no mention about any injury and other things, Lordship. They have to state, but the
Page.
Learned Council,
Page.
page 14, paragraph 15, Lordship. The aforesaid order dated
No,
20,
the prescription is here at page 53.
yes. There is no mention about any injury.
Page 53.
53.
You see, it's mentioned there pain in right knee
Pain in right knee.
for 2 months.
Everybody has right pain in right knee, left knee, Lordship.
No, I don't know. I can't presume anything. You see, the second is swelling position, mild tenderness position.
Yes,
Then is advised kneecap. Avoids singing seated in cross leg.
it
and
is in
physiotherapy.
January 23, Lordship.
That
January,
is- that
more
is
than
okay.
3 months back.
You see page 54 again. Early degenerative changes.
Page 54, Lordship observation.
Degenerative changes in form of marginal osteophytes.
I have also said, Lordship.
No, that is okay. You see, we are not on personal
It-
reasons.
Subsequently, it is,
No, you see,
filed before this honorable court, Lordship.
a person personally doing something is not a general
And
rule.
he was present in the court itself, not this court, but ground floor of the court. Subsequently, next day he came and turned to page 14.
Oh, okay, then I'll hear Mr.
Lordship,
Ahmed first.
lastly,
Yes, okay, we'll hear because I have not given opportunity to Mr. Ahmed to argue.
yes, Lordship.
Then we'll hear your
Yes,
argument,
yes,
otherwise he'll be
yes,
prejudiced.
yes.
Whatever she has submitted, let her put it on affidavit. We'll give it. Let her put it on affidavit. We'll give it.
Okay, okay, heard. Mr. MZ Ahmed, and then senior counsel assisted by Mr. A. Datta, counsel for the petitioner. And who's for the and Ms. M. Dev Leonard, counsel appearing for the respondent. Issue notice of motion returnable in 4 weeks. Requisite text. You have given copy? You have given copy. Next, the extra copy of the requisition has already been served on the learned counsel for the respondent. Next, the learned counsel for the respondent objects to the prayer made in this writ petition. Stop. Accordingly, oppositor filed affidavit in replies. Affidavit in opposition is granted. Let the affidavit in opposition be filed at least 2 days prior to the next date of listing. List immediately after the ensuing summer vacation. I'm not fixing a date right now.
All right.
Meantime, you worship.
No, Lordship, immediately I have
Let us
objection
maintain.
about that.
Is they constructing?
This is the fall, today I have received one,
No, but no
Respect-
construction.
No con-
Lordship, they have annexed some of the photographs that was not earlier photographers of the respondent, Lordship. How they can, I have objection on that point, Lordship.
No, you can't object. You can't carry out a construction during the meantime. So the status quo of construction as on 23/6/2023 shall be maintained. Till the next date of listing, then give a fixed date of listing after 4 weeks.
26/7.
Good sir.
I'll just add there. For prayer on interim relief, the counsel for the respondent has serious objections. Be that as it may. According to the objection.
Item number 6.
Well, here in this matter, they're praying for the vehicles,
Just a moment.
but they've not been able to establish their credentials about the ownership of this vehicle. They are entitled to ownership because of page 16, according to the petitioner. They have filed an application on the strength of that, whether they are entitled to ownership of the vehicle. No supporting documents, no registration certificate supporting that, nothing, Ballard.
Registration will be available with the vehicle.
Let the owner come with the documents, Ballard, the vehicle will be released.
No, page 12 is set is that it's a proof of identity of the ownership. The registration certificate.
Happened at 14, please.
Page
And the
14.
person who comes, Ballard,
Huh?
and the person, his own. The suspicion is this is a stolen vehicle, Ballard, according to the police.
But Mr. R.C. Das, then counsel with the petitioners. Who is this petitioner number 2?
Petition number is driver lawsuit. Namely lawsuit. Khairul Islam lawsuit.
It's okay, but who is he?
Doesn't
It
even
is a
say
driver
who.
Driver lawsuit.
Where is your statement there? Under the Motor Vehicles Act, is a driver entitled to position?
Whatever lawsuit done so far as making when the police was in my vehicle, so driver was their lawsuit. So petition number 1 is the proprietor of this vehicle lawsuit. He was not there. I will state lawsuit.
Just a moment.
Para number 5 lawsuit I will state it. Is a 10 line lawsuit from the top lawsuit. May I read lawsuit para number 5?
Yeah, just a moment. Uh, As this. Heard Mr. Hasidas and constitute the petitioners. And Mr. S. Sharma, Learned Government Advocate appearing for all the respondents. For all the respondents. Next paragraph. The case of the petitioner, in brief, is that on 9/5/2023, at about 6 p.m., the vehicle of the petitioner bearing registration number AS12-U-4457 was apprehended. He was stopped and the driver of the vehicle, the petitioner number 2, the driver of the vehicle was taken into police custody. And it is alleged that the petitioner number 2 was physically and mentally tortured. Full stop. Thereafter, on 29/5/2023, the petitioner had appeared before the officer in charge of Murajhar police station for having his vehicle released. But neither the petitioner was disclosed the case for which his vehicle was detained, nor the vehicle was released. Thereafter, another representation dated 6/6/2023 was filed before the Superintendent of Police Vijay within packet respondent number 4. But still his vehicle was not released. Hence, this writ petition has been filed under Article 226 of the Constitution of India. Next point. The matter was previously listed on 19/6/2023, and this court had directed the learned government advocate to obtain instructions. Full stop. The learned government advocate has produced the instructions under memo number Roman 4 of the RSI-WPC within bracket Miss MISC bracket close oblique HJI oblique 2023 oblique 639 dated 22/6/2023. Full stop. The contents of the said communication is quoted below. Much better. issue notice of motion recommended within 4 weeks. Revisit extra copies of the petition which served on the learned state and departmental council in course of the day. Next paragraph. Ordinarily, we heard both sides and they prepare for interim relief. Next paragraph. Ordinarily, this court would not exercise power under Article 226 of the Constitution of India for considering the prayer for Zimma of the custody, which is essentially a power bestowed on the jurisdictional magistrate under the appropriate provisions of the Criminal Procedure Code. Next paragraph. However, comma, in the present case in hand, from the hearing before referred, report from the Superintendent of Police, Hojai, dated 22/6/2023, comma, there is no indication of any police case having been registered. Stop. There is a reference that there was a secret information received on 9/5/2023 that the vehicle of the petitioner was carrying a huge amount of narcotic drugs, for which Chaudhary Bazaar PP GDE entry number 134 dated 9/5/2023 was registered, was entered. Full stop. However, the report does not indicate that any narcotic drugs was being seized from the vehicle. Full stop. Accordingly, in the absence of any FIR or a police case requiring the vehicle for any investigation whatsoever, comma, the court is inclined to direct the Superintendent of Police, Hojai, Assam, within bracket respondent number 5. No, 4.
4, I'm sorry. 4.
To personally to release the vehicle of the petitioner to him on his appearance before the said authority, along with his proof of identity. Next one, it is further, the court is further inclined to direct that the Superintendent of Police, Hojai, shall not detain the petitioner for more than 30 minutes for the purpose of inquiry, and the Superintendent of Police shall docket the time of appearance of the petitioner and his time of his release, and a memo to that effect shall be sent to this court through the learned government advocate. Next, the petitioner is permitted to produce a certified copy of this order before the Superintendent of Police, Hojai, to bring the order to the notice of the said authority. Next para, distance so and so. The report dated 22/6/2023 is kept as a part of record.
28/7.
Next time, Mr. Sharma, if you are there, or you can make a note, you'll also address us. Any rules under the Assam Motor Vehicle Rules or the Motor Vehicles Act, which permits you to have to inquire as to why the driver was driving the vehicle. Because my vehicle, my driver drives, correct? So apprehension is that tomorrow, the police may even stop my vehicle and detain that vehicle just because my driver is driving, because I don't give my driver a letter of authority to drive my car. So my wife may be traveling, my son may be traveling, my other relatives may be driving the vehicle, and suddenly they will be thrown out into the street. Because my family has to travel. I am detained in my own home. I am under house arrest at all points of time. Therefore, I can't go out anywhere. But my family does travel.
Yes.
It's only for that purpose I am trying to understand. Even Dr. Saraf, I don't think you are driving a vehicle. You don't drive a vehicle. You see. You would not like Dr. Saraf to be stranded out on the road when his driver is going out. Maybe Mr. Kyal will accept, but not Dr. Saraf. No, I don't want to stand up. I'm just making my mood lighter. Yes.
So when
Yes, Mrs. Hazarika, will need you. This you have seen this repetition. I'll just tell you, just be here. On the speaker, I think your speaker is off. You see, land demarcation was made.
Not true.
Petitioner files an objection.
Not true.
And that objection, what you call, you're doing nothing. It was filed on 17th for 2023. Objection must be registered and taken up. Yes, that is all.
Annex 8 of application filed by the respondent.
Where is the order? Where is the order of demarcation?
Regarding Your Lordship, I have annexed the Chita, page number 24, annex 6, my lord.
Oh, no, this is a, what you call,
Yeah, here it
correction,
is
correction
written-
of land records.
Here it is written in compliance with order dated 8/6/2022 in partition case number so and so the land measuring 5 acres 17 acres of the state.
No, you're
land.
reading where? You're reading where?
And page 24, annex 6.
24. Oh, this is correction of land records.
Now, a separate patta was created, my lord, in earlier, in compliance with the order dated 8/6/2022 in partition case number so and so, the land measuring 5 acres 17 acres of the.
So where
state
is this partition case order?
Partition case order has not annexed. my lord.
No, I was wrong. I was referring to a different matter. Not this one. But there has to be an order. Only after that. This-
Order was reflected in this annexure 8/6.
No, you don't understand what is going on. If there is an order of partition, then what is wrong? Because then your this page 25 petition is by you.
No. Page 25 is complaint before the deputy commissioner. my lord.
Who has done it?
My petitioner has done. it.
This is by petitioner.
Hmm.
Then this will be incorrect. If there is already an order of what you call partition case of 8/6/2022. 8/6/2022 is nowhere reflected here. Then you have to dismiss your petition.
No, my lord. Okay, paragraph number 2, I have stated that the complainant daughters named in Najmina Khatun, Aisha Siddiqa, Elima Khatun, and Yasmina Pabri, all are daughters of Jahanarabad and also parties.
No, Mrs. Roy, you see, this, Ms. Roy, this will not help you. There is a partition order. Without referring to the partition order, how can you
Then
make a
your lordship-
representation?
Then your lordship fixed it up in the next week. I will.
It goes after vacation because the next week is very difficult time. In your writ petition, have you referred to this partition order?
Partition order, I have not analyzed, my lord.
No, but have you made a statement?
In paragraph number 7, my lord. That the petitioner petitioned that thereafter they filed a partition case being numbered so and so for partition of the shared land, and accordingly by daughter did a separate DAG number that was created in the name of the petitioners.
No, then your reputation would not be maintainable. It will not be maintainable then.
No, my lord, I have approved before the deputy commissioner.
It would not be maintainable. You see, the simple reason, the partition, the sale was done on the basis of right created under sale deed number 54533 and 4837. So title has been derived. If on that basis a partition is done, you can't, what do you call this, challenge that by way of objection against partition order, against the creation of
I am
the.
not challenging. The private respondents filed an application before the circle officer.
Correct. Correct. So you are objecting to that.
Yes, ma'am.
You see, let us say, take an example. You put yourself into the place of the one of the litigant. You have purchased a plot of land and you have applied before the authorities for partition of your share. Is it illegal? You see, if you put yourself into that place, then you will find it is not illegal. If you purchase a land, my question is that you have purchased, supposing you have purchased a land and you have applied for your mutation and partition, is it illegal?
No, my lord.
Then,
I am not object. My partition is created in my name, in the name of the petitioners, my lord. The private respondents filed an application for cancellation of parta. Application is at page number 8 and 8 and page number 28, my lord.
28.
Vernacular is at page 29, my lord.
Okay, then what has happened?
Regarding this, I have approved before the deputy commissioner. But no response was given, my lord. And the Lat Mandal has submitted that and report against me, my lord.
Where is that?
Lat Mandal report is at page annexed 13, page number 40.
Yes.
Right. Vernacular portion is at page number 43, my lord. In the real sense, last of page number 40. In the real sense, the disputed land measuring swings has to be divided equally in 3 parts. That is 4 bigger acreage in the name of Babar Ali, 4 bigger acreage in the name of Samad Ali, and 4 bigger acreage in the name of Kushal Puddar. In the said situation, the younger son of Kushal Puddar, Javed Ali, by dropping out the name of his father, has inserted his name in the record. The name of Abdul Rahman Poddar, Master Ali Poddar, Asad Ali Poddar were dropped out from the record. On the field verification in Khatir number 6, tag number 1 in respect of land measuring 5 bigger 17 ledges, name of the first party so can be corrected by dint of their possession. I have annexed the Khatir numbers.
Oh, okay. I get it now. Okay. Good. Is there trial and counsel for the petitioner? And Mrs. G. S. Adhikal and Standing Counsel for the Revenue Department appearing for respondent number 1. And Ms. S. Sharma Tanel, Government Advocate appearing for respondent number 2 and 3. The case of the petitioner, in brief, is that he had purchased possession of a particular plot of land. Had purchased Raiti right in respect of 1 bigha 0 kata 10 lecha land in his possession out of 4 bigha 0 kata 8 lecha covered by card number 122/101 of pata number 2 within bracket old of village. What is the name of the village?
Village is,
Along-
Alamganj Part 7.
Along ALOM, along Ganj GNJ, part Roman 7, comma, Moza. Yes, where is that Moza?
Moja is, under Circle Gauripur District, Dhubri.
Moza Dhubri, circle, Moza and circle Dhubri. Right, cell deed number 2059/1886 dated 17/9/2014. The name of the petitioner was mutated in the revenue records along with the pata holder of the said land.
The petitioner purchased the sale, disputed land by two sale deed, my lord.
I mentioned that. Full stop. Thereafter, the petitioner applied for partition. And accordingly, partition was allowed by order dated 8/6/2022. And a separate DAG number 340, pata number 45 was created in respect of the said land. So thereafter, the private respondents had applied for cancellation of the mutation. Where is that petition?
The application is the page number,
31,
annexure A, page 28.
28. For cancellation. And your reply is at page 35.
Page 35. Annexure
And
12.
in respect of the said application, a case being GMC Miss 2023/5 was registered for the circle officer, Gauripur Revenue Circle, wherein the petitioner filed their objection as well as written argument. The petition is agreed by the report of the allotment to the circle officer, Gauripur Revenue Circle, indicating that an order can be passed for correction of the land record by inserting the name of the objector, i.e. the private respondents, by dint of right of possession. issue notice of motion return within 4 weeks. Requisite extra copies of the petition we filed, we served on the state and department council in course of the day. Petitioner shall take steps within 2 days for service of notice on the private respondent numbers.
Lordship,
4 and 5, yes,
our name may be reflected in the process.
4 and 5 by registered post with AD. Next para. In view of the projection made in this writ petition, which is supported by entry made in the Chitha. Within bracket, page 24. That the separate DAG was created pursuant to order passed in partition case number capital DHU oblique GRP oblique 2021-22 oblique 76008 oblique FERT. This is page 24. The circle officer Gauripur Revenue Circle, while determining the matter before him, i.e. case number GMC oblique Miss oblique 2023 oblique 5, shall first determine whether he has the jurisdiction to cancel the order of mutation, and only on recording of that, on recording of such satisfaction, just as written so under the provisions of the Assam Land and Revenue Regulation, and on first adjudicating on his jurisdiction, thereafter he will fix another date for passing final orders in this matter. Next, as an interim measure, the court is inclined to provide that whatever order is passed by the circle officer Gauripur Revenue Circle cannot be implemented till 26/7/2023. Next, based on 27/6/2023. Next, the petitioner shall produce a certified copy of the order for the circle officer Gauripur Revenue Circle within bracket respondent number
Question number 3.
3, putting the order to the notice of the said authority. Petitioner is S. This case number GAU that you will find at page 35. So you may go ahead, but we'll first determine his jurisdiction. After that, he will pass on order.
Lordship, our name may be.
The registry shall reflect the name of SC Revenue when listing the matter next.
Departments.
8,
May it please, my lord.
Yes,
My lord, the petitioners have been residing in a particular
but
area.
we can't issue a notice in this case. You see, you have produced a copy of this page 21 photograph.
Yes, your lord.
This committee itself is not before us. You have not made them parties.
Lordship, it functions under the deputy commissioner, your lord.
No, that I don't know, but if it is an entity,
I could not locate it in the internet at all, your lord.
no, that is okay, but you have found this name. You are saying that it is working under the deputy commissioner. At least it could be implemented through deputy commissioner. Make the correction, we'll take it up next week. Without the necessary party, we can't pass an order.
They don't have a semblance of a right over the land.
No,
They
he's
have-
made some agriculture, his prayer is to allow him to harvest it. That is the only prayer. What is the semblance of right going to do there? He has a cultivator, he has sown rice there. You let him harvest it, you do whatever you want with that land. He's not asking a right for himself. 5 or 6 people, they have harvested about 20 bighas of land.
29 people,
Whatever be, they have harvested so much of
30
land.
people.
They have harvested so much of land. Why you want to deprive them of their small amount of rice? And then you distribute it free. Rice under the schemes is distributed free.
We harvested within at most 2 months.
Why at this moment?
Beg your lordships, pardon.
Why at this moment when the rice is ready for harvesting? There's no prayer for any other right. But you impede them and bring it on record next week. Both sides are represented. As the society for whom the land has been reserved is not a party. As the counsel for the petitioner is permitted to amend the cause title by inserting, by implementing necessary party to the deputy commissioner, which place?
Dorong Yolo.
Darang. The correction shall be done in the presence of registrar judiciary. And the petitioner shall provide freshly typed cause title to be inserted in the cause title after implementing list as when corrections are made.
9,
Much obliged. My lord, can it be indicated that we'll make the corrections by Monday, your lordship,
I said you can do it.
sometime in the next day.
You do it whenever you do it. Made a mention list after the corrections are done. If you can do it today, you can do it.
Lordship. Much obliged.
May I please, your worship?
Yeah.
My lordship, I have nearly 1 bigha and 13 kata of agricultural land, my lordship, where I used to do rice cultivation, and I had 1 pond, my lordship, where I grow fish, my lordship. On 4/4/2023, my lordship, few officials of the Lala Revenue Circle, my lordship, they came to my land and demarcated nearly 8 kata of land from my.
I'll issue notice. Heard. Mr. S. B. Laskar and counsel of the petitioner. Ms. M. Burman and the government advocate appearing for the respond number. Two and 3. And Ms. Ms. G. Hazarika, the standing counsel for the revenue department appearing for respond number 1. And Ms. A. Das, the standing counsel for Health Department appearing for respond number 4. Next paragraph. Issue notice of motion written within 4 weeks. Requisite extra copies of the retribution is served on the run at state and department council in course of the day. Petition shall take steps for service of notice and respond number 5 within 2 days for by registered post with AD. Liberty to correct postal receipt number file track report. Next paragraph. From It is projected, heard both sides on the prayer for, all sides of a prayer for interim leave. It is observed that against the demarcation of the land of the petitioner, objection has been filed by the petitioner. Objection dated 17/4/2023 has been filed before the filed by the petitioner before the Deputy Commissioner Haila Gandhi within bracket annexure 8. So accordingly, it is provided that till the next date of listing, the respondents shall not carry out any improvement. Would not would maintain the status quo of the land as on today 23/6/2023. Next, the petitioner shall produce a certified copy of the order before the Deputy Commissioner Haila Gandhi to bring the order to the notice of the said authority. Just after 4 weeks.
Deeply obliged, man.
Right.
Or Mr. M. Hussain on counsel for the petitioner, and Ms. S. Sharma and the government advocate appearing for the respondents. Before all,
My lord.
no, you will be for 1, 3, sorry, 2, 3. Uh, 2 and 3. Union of India, you'll be there, Mr. SP Chaudhary Leonard, CEC appearing for respondent number 1. Next paragraph. Agreed by non-release of compensation through DLSA is ordered by the court. The present petition has been filed under Article 226 of the Constitution of India. You should notice the motion return within 4 weeks. Requisite extra copies of the petition be served on the CEC, State and Department Council in course of the day. Next, the petitioner shall serve notice on the respondent number 5, 6, and 7. Should take steps within 2 days for service of notice on 5, 6, and 7 by registered post with AD. To stop in addition, notice on respondent number 5 shall be served by Dasti, routing the process to the registry of the court. And upon service and affidavit of service shall be filed prior to the next date of listing. Next paragraph.
I submit on
The
my lord. In
Pendency
the,
of the writ petition shall not be a bar for the respondent authorities to release the compensation through DLSA's a direction of the court. Where is that order?
my lord. Yes, 55, my lord.
Page 55. As per order dated 5/5/2022, passed by the District Legal Services Authority, Kokrajhar, in proceedings number AVCM, full stop number 11/2022, within bracket annexure 12.
My lord, in the earlier occasion, my lord, the government advocate has received the notice on behalf of the DLS. And
No, I don't know whether they are about to do it or I don't know. Because
Yes,
this is an establishment. You're receiving it? DLSA? DLSA, you are
madam.
receiving it?
5, 6, 7. Yes, my lord.
You will
Yes,
be doing it, okay. Then for that also, what do you call it? Who are there? 5, 6, and 7.
and 7.
5, 6, and 7. But you served notice on the
Yes, madam.
legal service by the state,
My
number
lord,
5, no steps. 5 should appear.
And my lord,
Okay.
let the matter be listed along with WC
No, no, I'm
36
not
on 7.
listing,
Similarly situated
No,
matter.
no, I'm not burdening myself. Each and every case will be decided on the rate. We don't know whether this is not a case for final hearing on merit,
Yes, my lord.
then why should I?
Obliged.
Yes, IMFL,
My lord, my lord.
okay.
Organization finance this, my lord.
IMFL license, no? Mr. D.K. Das for the petitioner. You should notice, pendency shall not be allowed for the authorities to examine the claim of the petitioner for an IMFL on license. You are appearing for? Put on the speaker. I'm not hearing you.
M. Kalita, your lordship,
I'm Kalita, for
Excise Department.
accept the respondent numbers.
1, 2, 3, 4, 5, 6.
All of them.
No, except 7, all the respondents.
Which 7? You are, Mrs. Sharma, they are going to be 7. Okay.
Well,
There is one more matter,
Yes, my lord. Item number 18, my lord.
18, okay, same order.
Pendency, my lord.
They're also respondents the same,
Same,
Lordship,
okay.
obliged.
obliged.
well,
Non-payment of bill.
My lord.
Mr.
You does, my lord.
You have for the petitioner, Mr. S. K. Medi, then CEC appearing for respondent number,
All respect.
for all the respondents. And Mr. S. R. Ravat, and then
My lord, BTC's name is reflected, my lord.
But they are not part.
It may be dispensed with, since there is no role.
They are not party also, my lord.
oh, acha.
But it is made a party, my lord. They are formal for that.
But they are not party. The giving non-payment of bills, the present represents in filed in Article 26 of the Constitution. Notice, extra copies. Next paragraph. The registry shall, as BTC is not a party in the repetition, comma, the registry shall omit the name of SCBTC in the cost list while listing the matter next. But just record his presence, Mr. Rava, standing counsel of BTC is present. After 4 weeks, pendency shall not be a bar.
13,
Yes, Mr. Gogoi, this has to be stated.
Lordship may indicate that no coercive action in the meantime.
Okay, no, just tell me, this tax
Otherwise-
tribunal is functioning.
Tax tribunal.
Hmm.
But it is there otherwise, madam. Madam,
Tax tribunal is functioning,
no, there is the revenue, Assam Board of Revenue, madam.
Board of Revenue.
Yes.
Then why you,
You see, without jurisdiction, when you lost the assessment has been completed, absolutely period of limitation.
limitation,
That's
okay.
without jurisdiction.
Dr. A. Saravanan, counsel for the senior counsel, assisted by Mr. Anand Datta, counsel for the petitioner. And Mr. D. Govil, and standing counsel for the
Finance taxation,
Finance Taxation Department, for all the respondents,
all of it.
okay, for all the respondents, thanks for that. Issuing the orders of the orders are 12, 5 and 25,
Milo, the order detailed, assessment order,
12, 5 and 25.
Milo.
Well,
Orders dated 12, 5, 2023 and 25, 2023 passed by the assessing authority. Uh, on the ground that the orders are beyond the period of limitation, the present writ petition is filed under Article 226 of the Constitution of India. You should notice extra copies for both sides on the prayer for interim relief till the next date of listing, comma.
madam,
The
no
respondent
coercive
authorities shall not
action.
take any coercive action against the petitioner in respect of the assessment orders referred above.
Under assessment, yes, may be mentioned, but 3 assessment years are there.
Yes.
Okay,
15, 16, 16, 17 and 17, 18.
in the top. For assessment years 2015, 16, 16, 17 and 17, 18. Okay.
I'm obliged.
14,
Oh, but Dr. Saraf. Just a moment. I received your message, very wonderful work you have done for that school.
Some contribution, something can be done.
No, very good.
In fact, we are undertaking this construction of the school also. The old home we have dismantled.
No, that is what is praiseworthy. That is why I am acknowledging
And,
that in
we
this
are
court.
constructing a school there.
Very good work. Very benevolent, in fact. You know what he has done.
Yes, that's-
Ah.
I know. I will inform him also.
Okay.
I'm grateful to you, Lordship.
Yes,
Maybe
your case also, is there a tribunal functioning
Yes, Lord.
against the order?
Yes, Lordship, in Calcutta. Lordship, here revision is there. So
My lord, here also my prayer is that the orders are expressly without jurisdiction.
Why?
Because these are exempted items, my lord.
No, you see, there are difficulties.
Lordship.
Because he has given a reason for why that has been discarded.
But my lord, my prayer is that he has not given me adequate opportunity, my lord. My lord, if I am given an adequate opportunity, I will produce the bills and the bank entries which will show that the particular financial.
Show me
year-
that part. Show me that part.
Yes, Lordship. Lordship will first have the SCM, the so-called notice, the relevant portion, Lordship will find at page 122.
No, I've seen that.
Yes.
There is also mentioned that at the relevant time, we did not produce any supporting documents.
No, my lord, I made the prayer, my lord. That is it, my lord. I made the prayer that I may be allowed some time to produce all the documents that was not recorded, my lord. That is the irony of the situation, my lord. If given an opportunity, I will produce it. Admittedly, my lord, these are not taxable items, my lord. Because even a prime contractor, be it a prime contractor or a subcontractor, the central government. by
That is
law-
okay, but this 163, there is a record that notice it did not submit the required documents.
My lord, that is, my lord, I deny, my lord. I deny, my lord. And my lord, the also, my lord, the exercise which they have done, my lord,
No, but show me the error in the this appellate order.
my lord. My lord, the entire assessment has been done, my lord, the appellant impugn order. If your lordship peruses
Which page?
page 1203, my lord.
203.
203 is the relevant portion, my lord. My lord, there is another aspect I am showing your lordship. First of all, department has granted me the exemptions, my lord. The original assessing authority.
It accepted your contention.
Lordship, original assessing authority accepted my contentions.
But he
Then
has
there was a
given,
revision done. In that revision, I was not made, no notice was served upon me, my lord.
where is that? Show me that.
Yes, lordship. My lordship, I am showing your lordship the operative portion of the order, my lord, against which I am agreed, my lord. If your lordship peruses, I confirm that the demand of service tax, including applicable sales of rupees 83 lakhs 22,750 on the respondent in terms of section 73(1) of the Finance Act as amended. I also order recovery of interest applicable on the rate from so and so. I also impose penalty, my lord. Interest, penalty, everything has been imposed, my lord. Can
Yes,
it be the
okay.
case, my lord? Can it be the, it
No,
can,
that power is there in the act itself.
my lord, that is there, but my lord, the entire, whatever transaction I had done during that particular financial year was with railways, my lord. I have the bank documents to produce so that I have the audited book of accounts.
No, it's okay. You just trying to satisfy me that your contention is that you are not heard. Show me that.
Yes, lordship. Lordship will kindly have, my lord, page number 122 of the SCN, my lord. The figures I am showing your lordship, my lord. Page 122.
Because if I can show you page 163, it means that I have done some homework in term.
My lord, may I just take your lordship?
Yes, show me that page.
Page 122. What is the gross figure that they have found, my lord? The gross figure for the financial year, my lord. My lord, If your lordship peruses page 122, which is a part of the
No,
original.
no, please
Sokos-
don't come back to the demand come show cause notice.
My lord,
You'll have to show me the appellate order.
lordship. Not the same figure, my lord, same figure.
It's
Same,
okay.
same amount, my lord. Even in the
You
appellate.
see, there is an English saying,
Lordship.
beating around the bush. Doesn't help me.
No, I understand, my lord. I understand.
I'm putting up a pointed question, you are respond to only that.
My lord, that is the same amount which
Because
they have.
then we'll take it up at end of the day. I can't spend so much of time.
But see, here, the issue
My
is
lord,
that
if your lordship say.
I'm giving an opportunity, you to now take it at the end of the day. Pointed question, you give a pointed reply. Thrice I've asked you. Fourth opportunity, I don't have that much of patience.
My lord, at page 200, they have recorded the figure,
No,
my lord, which is
not
my.
at the end of the day,
Lordship.
4 o'clock. Yes, what you were trying to say?
lordship, page 200, paragraph 11. Their main contention is that they were not heard.
Yes.
But see, initially, the executive authority dropped their demand, their department filed appeal. In appeal, lordship, paragraph 11, their main contention is that they were not.
Page.
Page 200, paragraph 11.
Yes,
Personal hearing in the case was fixed on 3/1/2023. Sri Shankar Majumdar, cost accountant, the authorized representative of the appear on behalf of the respondent for personal hearing. During the hearing, he submitted some written submission along with copies of the sum of their work orders and assessment agreements in support of their claim. So their contention that they were not heard and no opportunity was given, it was absolutely incorrect. And thereafter in paragraph 12, lordship, I find that the adjudicating authority in order in original has conclusion solely on basis on the notarized agreement dated 4/2/2012, by which supposedly the NF Railway had awarded work order for supply of installation testing commission so and so, amounting so and so. Then next paragraph 13, the executive authority in para 5.3 of the order in original has further stated that the contract value of the aforesaid work was raised from so and so so and so. Then paragraph 14 is important also. The executing authority has further suggested that Mr. Bihar and Infrastructure Limited, the main contractor, has provided service classifiable under work contract of the railway, which is exempted from the payment of service tax by way of exemption notification so and so. The executing authority concluded the respondent subcontractor had provided service under work contract to the main contractor and following SN number 29H of notification so and so, and exempted available in the mega notification dated so and so would be available to the respondent. The executing authority has not mentioned any work order number agreement related to the said agreement dated so and so, and has not even given a discussion detail of the work based on which the entire conclusion has been arriving by the executing authority. However, on perusal of the documents on record, including the submission made by the respondent, I note that there is a notarized agreement dated 4/2/2012 between VRN Inspector and MR Associate, that is respondent. The notarized agreement of subcontract work awarded to Mr. VRN Inspector by NF Railway by its LO number so and so for a value of rupees so and so. No detail regarding completion work could be seen in this notarized agreement. I further note that there is a document dated 29/2/2012 of NF Railway mentioning contract agreement number so and so. As per this agreement, the contract, the completion period of the work order has been provided within 8/5/2012. It is thus evident this record, the work supposedly considered by the executive authority was required to be over by 8/5/2012. However, the period covered in the impugned so-called notice is consequent to with original order is financial year 2014-15. The work was completed in 2012. And the so-called notice was issued for 2014 and 15. So it is beyond that period. So the order in
No, it's
original
okay.
was
You see, yesterday, the court time was 4 o'clock,
Yeah.
4:30. I continued beyond that. Correct. Would my orders passed after 4:30 become illegal? In a contract, Supreme Court in way back in 76 has said that time is not the essence of contract. In a construction contract, Supreme Court long back, it's a
Yes, Lordship, that
decision that is still a Bible for us, that time is not the essence of the contract. So you see, just because your assessing officer does not write the particulars, will tax be added to someone?
no, Lordship, here. the
Second thing, this authority I can understand, can assess the tax matters. But can he go and start interpreting an agreement?
No, Lordship, here, they are claiming the exemption with respect to agreement entered in 2012. And the demand is for 14 and 15. That was not considered. And he is taken into note that notarized agreement and the work was completed in 2012.
Have you seen any railway contract with a registered agreement?
Lordship,
Have you
they have not provided all these documents. They provided notarized
My
agreement
lord,
only.
time was extended, my lord. EOT
Please,
was
why you
done.
are disturbing the court proceedings?
Okay.
Why you are doing it? I'm trying to understand something in your benefit and you are again
I'm-
not doing it. You're not permitting me to go ahead.
My lordship.
Correct. You can just turn around and see how many done it. Senior counsel and counsel are sitting. Just turn around. Mr. Rahul, just turn
My
around.
lordship.
I'm directing you to turn around.
My lordship. Senior.
Turn
I
around
apologize,
and
no, my lord.
please
Since the
turn
court-
around.
My lord,
Don't
please.
annoy me.
I'm not.
I'm asking you to turn around and look at the number of counsel and senior counsel sitting behind. Correct. I have a duty towards them also. When I'm asking, I'm regulating the court proceedings. Please, for the third time, I'm saying, please maintain that decency. And where have you learned? From whom have you learned that when Mr. Kyal is addressing, you will stand up and start arguing?
Well,
Where have you learned that art?
I just pointing out to your lordship that
No, you see,
EOT was
I
done.
understand. This is not a debate in the parliament. Where everybody can shout, go to the well, raise voices, throw chairs.
I apologize.
It's not a parliament well,
I'm sorry.
where you can just come in, barge in and then start shouting.
I'm sorry.
I'm asking question in your favor and you are trying to disturb the court proceeding. And then also when Mr. Kyal is making his submission and you made me forget everything. We'll take it up the second half. No problem. When you disturb me again, I have to read everything. What Mr. Kyal is saying, you asked of. This is something I will not tolerate.
I apologize. I was just trying to speak it.
Ebook of that is souvenir of the Platinum Jubilee celebrations. Now, tomorrow, Monday, it will be inaugurated formally, and then it will be open in the public domain. You can download it or see it. Monday, we'll be launching it formally. Yes, item 15.
Item 15. May I please, your lordship? May I please, your lordship?
Just a moment. Yes,
I may be given with a copy of the petition as I am appeared only on information.
okay, give him a copy. But this proceeding, you'll have to, this has to be stayed. You give them a copy. I'll tell them.
Lordship, it is only the legal notice that has been.
No, but you see, nobody knows if sufficient action is taken. You see the petition, I'll just give him a copy,
Yes,
Mr.
yes,
Tambari.
I have.
Give him a copy. Give him a copy. You come to page 37,
Yes, your lordship. 37, your lordship.
37.
Yes, your lordship.
Yes, you see, now you see in 37, repayment schedule has been recast. You've seen that? Repayment schedule from the month of 1st August 2022. You've seen it?
Yes, your lordship.
Correct. Now come to next page, page 39.
Yes, your lordship.
Page 39. last 5 entries starting from 18/8/2022.
Yes, your lord.
Last 5.
Yes, your lord.
This is 12 lakh, sorry, 1 lakh 20. Sorry, 12 lakh,
12 lakhs, your lordship.
12, 1, 2, 3.
Yes.
The next page, 4, 5. Again, there was a default, correct? So 4, 5, 6, 7, 8. Then again, because of his default, is now paying twice the amount. 250, 250. You've seen that? So I don't find any default here.
But your lordship, the legal notice has been issued
No, it's okay, but you
and
you're
legal
not taken
notice-
into consideration the payment made. This OTS itself is not taken note of. This
can
nothing
it be
in this.
taken up on Monday, your lordship, if allowed?
Okay. Monday. List on. Both sides are represented. Mr. S.N. Tamani, counsel for the petitioner, shall provide a copy of the petition to Mr.
M. Sarma.
M. Sharma, counsel for the respondents. List again on Monday, 26. Okay. So that is the only thing. That is the only point.
By the end of this month, we will pay the remaining 15 lakhs. By the end of this month, we will have to pay another 15 lakhs. That will clear it.
16.
Yes. This lowest bidder kindly explain it to me.
I'll just
How,
explain.
huh.
Yes. I'll
That I
just
couldn't follow.
Yes, I'll adjust it.
Hmm.
My lord will kindly see what is lowest bidder and how it has been. Page number? No, not completely. Very good advice. I'll just explain to you. Page 57, my lord, 57.
No, go in your own way. This is one of the query.
Yes,
You go in your own way.
you know what I am saying, that what is lowest, how it is, that's, I will just point out that. That will be easier for your lordship. The first query, that's why I have to give a reply to your query.
No, I'm giving you an opportunity.
Yeah, no,
I'm
no,
giving you
my
liberty. You
lord.
can go ahead as you.
Kindly
as
see
you prepare.
57,
Yes.
3. Evaluation criteria, qualification evaluation, 3.1.1 terms and condition. Number 2, lowest total L1 bidder will be selected.
Yes.
Lowest total L1 bidder will be selected. Successful bidder should supply all the items given in schedule 4. So, my lord, what is lowest total L1 bidder will be selected. Now, if your lordship kindly see the 92, see 92. 92.
Yes.
This is a chart which has been given in the website. If your lordship kindly see 1, schedule of the work. This is group D fish, my lord. Name of the work
Yes.
is supplying of ration feed material under group D fish for the financial year 2023-24. Now, schedule of the work, kindly see 1.
Yes.
It's a big fish, rohu, borali, sold not less than 1.5 kg. That's a rate is, my lord, number of quantities 1825. That is 1825 kg for the year, my lord. Your lordship will note down for the year. So this is the base price which they have given. Estimated rate is 715. So my lord will kindly note down. They cannot quote, no one can quote above 715. So
Yes.
it cannot be quoted above 715. That's the estimate. Now, OSS Enterprise is a petitioner before your lordship. Now, the rate which is quoted is 250. Now, amount, if you multiply 1825 into 250, the rate which he has given again 715, it will come to 456250. Lordship, got it? Now, kindly see number 2 is the medium small fish so and so. This is 27375 is the quantity.
So estimated rate is 522.50. So it is below 225. So if you multiply, then what is the amount? It's 61593, so and so it comes. So 3 also 12485, quantity estimate rate 1045. Now he has quoted 940. Now 4 also, that is 1.00 kg. Now 577 is estimate rate. I quoted exactly on the estimated 5. So if you multiply this, it comes to 577.00. So if your lordship now see the table kindly see last table. So DS Enterprise is respond number 5, which I made. So his rate is L1, kindly see L1. But I challenged this petitioner on the ground that he technically is not qualified also. Number 2 is the petitioner, who is L2. Number 3 is one Muhammad Yassin, is maybe his L3. L4 is Suranjan Deka. His rate kindly see 1 crore 52 so and so. So if I have to pay to the government, now that is always, my lord, it will be high. Now suppose government one has to pay, government has to pay to me, then it is always lowest. So in this case, what they have done, instead of settling to the either L1 or L2, they have settled with L4, whose rate is 1 crore something. So the government has to pay them, which is high the amount. So in tender, what it says, my lord, it has to be settled with L1. Now we are L2. L1, why his case, technically he should be disqualified. Kindly see, my lord. We have challenged that also. Kindly see at page 38. 1 second, 38, my lord. This is the document of Computer Technical Week. Kindly see Roman 11, Roman 12. Self-attested copy of valid veterinary trade license / GMC license for trade in animal products. It is not that you will just give a trade license, but it should be in animal products. Now, if your lordship kindly see the L5, that's what certificate he has given. Finally, see my certificate at page 77 first. See my certificate 77. GMC license. My lord will kindly see the name on the top, on the towards right hand side of the column, Nessus Oasis Enterprise. And kindly see trade type. Kindly see 1, supply, combination of 3 or 4 items, meat, chicken, so and so, issued for so and so. So this is what, my lord, a trade license is required.
Yes.
Now kindly see response number 6. L4, my lord, where a settlement order has been passed. L4, kindly see his bid document.
Is
Page 80, his is 87. 87. He has given a valid document. Response number 6, my lord. Kindly see, his name is reflected in the right hand side of the column. First, on the top, Suranjan Deka. Lordship got it? Now kindly see serial number 1, supply combination of 3 or 4 items, meat, chicken, fish, egg, issued for so and so. So this is actual, my lord, what has to be submitted. What is L1 has submitted, if we have 7, response number 5, at page 82, kindly see. 82. 82. So he has given a general license, my lord. Kindly see at 82, he is given a general trade license. Contract and supply, kindly see, subject to provision of GMC Act, laws made thereunder, license you have granted to so and so. Business type, contract and supply. Which is, my lord, not in consonance with page 38. 38. So technically he should have been rejected. So why now your lordship will ask me,
Why this cannot be interpreted to mean from elephant to helicopter?
but this is not, this is specific. That's why I'm saying.
Okay.
Specific, my lord. The trade license is specific here. So I have shown not mine, my lord. I have shown response number 6 also, my lord, where their settlement was made. Now why I made them a party? Your lordship may ask, the L1 is the lower L1. His price is more lesser than you. Why not? That's why we have challenged his settlement order or his technical, my lord, how technically he was qualified. Now kindly see minutes of meeting at page 88. Now kindly see 88. That's number 1. That is on 10/5/2023, my lord, minutes of meeting. This also has been put to challenge. Kindly see 1.
Yes.
10/5/2023. Just your lordship will kindly note it, my lord. NIT is of 13/3/2023. Just noting, my lord. 13/3/2023 is the NIT. Last date of submission was 5/4/2023. Last date of submission. Opening of the bid was 6/4/2023. 6/4/2023, opening of the bid. But
You're getting my voice? No.
uh,
You're getting the voice now?
yes.
No.
So, my lord, opening of the bid was 6/4/2023, but subsequently they deferred. And opening of the technical bid was on 29/5/2023.
29?
5/2023. Which your lordship will find at page 90, which I am showing now. Page 90. 26 or 25. Open on 25, download. It was open on 25/2023, but it was downloaded on 20th June 2023. Kindly see at page 90.
Yes.
Lordship got it. Technical bid, your lordship, I have shown only at page 88. 88, all technically qualified. Kindly see once again, my lord, 88. This is 10/5/2023. Now kindly see this at 1, R5. R5 we made a party whose the tender may be considered. Lordship got it? At page 88.
Yes.
Now second is R6. Same tender may be considered. Lordship got it? Now 3 is Yashin also, his tender may be considered. 89, see serial number 6, my lord. That's the petitioner. Tender may be considered. So I am challenging the bid of R5, where technically he should have been disqualified because he doesn't have that valid trade license for animal product. Now kindly see the financial bid at page 90. Now, if your lordship sees the bid list, number 3 at page 90, number 3 is DS Enterprises R5. Now, number 4 is the petitioner, admitted finance petitioner. And
92.
6, page 90, 90, page 90. Page 90.
Yes.
Now kindly see, this is the 20th of June, it was downloaded on the right hand side. If your lordship sees that 3, that is DS Enterprise, that is R5, admitted finance. Then 4 is the Oasis Enterprise, is the petitioner, admitted finance. And number 6 is Suranjan Deka, admitted finance, is R6. So we both challenge R5 as well as R6 in this R6. Now, kindly see down below, updated on 29 May, financial bid opening date is 29 May 2023 on the same day. Kindly turn to page 91. This is the 91. Financial bids are open for evaluation. Update so and so, updated so and so, BOQ comparative chart. Now page 92 is the chart. So here lowest amount quoted. Kindly see my lord on the at page 92 down below. Lowest amount quoted. They have written in bold letters by Messrs. GS Enterprise. This is the amount. Number 1. Number 2 is the petitioner. Number 3 is one Muhammad Yassin. Number 4 is Suranjan Deka. So his rate is L4. That's the amount which he has to give it to the government, is the highest government has to give it to him. So my case before your lordship is that how they have settled the amount which is L4, which is totally in contravention to page section 5, that is 57.
Yes.
So 57 is 2 is 3.111. So it has to be given to the L1. Now kindly see what they have done at page 93. 93. Kindly see 19.6. With reference, it is the info lowest bidder. Then how can it be lowest bidder, my lord? Kindly see.
We'll have-
10% delay of our booking.
Yes,
So my lord will kindly see at page 93.
yes.
This is also we have challenged 19/6/2023. With reference to your cited above, it is to inform you that the lowest bidder, that is Suranjan Deka, as per competitive statement, forwarded consider recommendation of examination committee against the item so hereby approved. So my humble submission that he cannot be a lowest bidder. This is my case. Secondly, I have one submission before Lordship. We mentioned it yesterday. The matter has come to end. What they have done, they know, my lord. Ultimately, what they have done very hurriedly, they have given to the respondent number 6, my lord, making whole petition. So my submission before your lordship is that immediately 19/6/2023. This because I have made a statement, whatever consequence to this also, it should be stated. And my lord, let the authorities run, Jew authorities run it. Why they should be allowed to run? Because ultimately the government has to pay to them at a very higher price, 1 crore something. That's my submission before lordship.
My lord, may kindly bear with page 30, my lord, that's the NIT. Page 30. 30. It is dated, my lord has seen on my 13/3/2023. It was for supply of ration feed materials for Jew captives under Group D fish. So if my lord now turns to next page, my lord, page 31. Open serial number 2, my lord, Roman small 2, page 31. It says, my lord, open competitive bidding method shall be followed for selection of most preferred bidder for the tender item. Not only, my lord, the L1. Then if my lord comes to page,
Then why have a tender at all?
my lord, what they have done actually, my lord, the market price after our scrutiny, my lord, we could come to learn the market price of a row or a Borali fish of 1.5 kilo each local, my lord, will cost around 500 to 600. He has quoted, my lord, 225. It is absolutely impossible, my lord. L1 doesn't mean, my lord, he will quote a price which is not reasonable, which is not, my lord,
That-
executable.
The criteria is there.
That criteria is there. I'm coming to that. Direct, it may not be directly, my lord, but I will try to satisfy your lordship.
Since I don't consume fish, I find everything in fish is fishy.
But I daily consume fish, my lord. I daily go to market. my
But that
lord.
is okay.
I also.
That is why,
daily go.
that is why I
Not
find
once,
So
everything in
225
fish.
fish, Borali fish of 1.5 kilo is
I'll tell
absolutely
you.
impossible, my lord.
No, I am not on that. Who eats is not the concern.
And that impossibility, my
question
lord, I
is-
can justify from records, my
Sitting here, I find that fish is always fishy.
lord. So page 45, my lord, may kindly come. Page 45, last clause, my lord, 2.28, determination of responsiveness. He has to be, L1 has to be responsive, my lord. 2.28.1, the bid evaluation committee constituted by the Assam State Zoo, Guwahati, shall determine the responsiveness of a bid to the bidding documents based on the contents of the bid submitted by the bidder. Now turning to the next page, my lord, page 46.
Yes.
Page 46, my lord, 2.28.2. It's very relevant, my lord. A bid shall be deemed to be substantially responsive if it meets the requirement of the bidding documents without any material deviation, reservation or omission where. My lord, will kindly take note of these three words, my lord. Material deviation, reservation or omission. Where deviation is a departure from the requirement specified in the bidding document. The reservation is the setting of limitation conditions or withholding from complete acceptance of the requirements specified in the bidding documents. Omission is the failure to submit part or all of the information or document required for the bidding documents. Now, next, my lord, a material deviation, reservation or omission is that if accepted, a material deviation is one that, if accepted, affect in any substantial way the scope, quality, and performance of the subject matter of procurement specified in the bidding document. So that will be a material deviation if we accept it. If we accept that price, it will affect, my lord, in any substantial way the scope, quality, and performance of the subject. Now, my lord, coming to next page, my lord, page 47. My lord, clause 2.30.4 down below D, my lord, D1. Clause D, small Roman 1. Fourth paragraph from bottom, man.
Page
47, man.
yes.
D.81. All supply items should be fully compliant with the Food Safety Standards Act, rules and regulations. All supplies must be fresh and hygienic, of high quality and without any contamination. Then, my lord, next page, page 48. Not 48, my lord. Page 55, my lord. Page 55, my lord, is the scope of requirement. The clause starts at page 54. At the bottom of the page, section 4, schedule of requirement. Schedule of requirement. Then turning to page 55, my lord, this is a chart. It says, my lord, column number 2. These are the requirement. Big fish, roe, borali, whole, not less than 1.5 kg. Then, my lord, approximate required, fourth column, my lord, approximate required quantity per annum, 1,825 kilogram. Approximate required quantity per day, 5. Threshold price. This is a price that we have fixed on the basis of materials collected from the market. Threshold price, our price was, my lord, 715 for raw fish, borali and whole. Next item, my lord, medium, small fish, puthi, dorikona, so and so, borolia, saying we have fixed the price, threshold price, my lord, will kindly see 522. These are the threshold price. If now, my lord, comes to the comparative statement as page 92. Comparative statement as page 92, my lord.
Just a moment, before I come to page 92,
My lord.
we'll finish this document
My lord.
itself. So what is the penalty clause in this document, tender document?
Penalty clause.
Penalty clause.
If they fail, my lord,
If any tender fails, what is the penalty clause?
there is one penalty clause here, my lord. Page 47, my lord.
47.
Page 47, my lord, clause. Just now I had pointed out D1, D2, now D3, my lord, bottom of the page. Any supplier who is found supplying food materials items listed in the bid in contravention of the above clauses shall be barred from further supply. His security deposit and EMD shall be forfeited and he may be blacklisted for a period not less than 5 years.
Good.
Now, if my lord comes to page 92. It's the comparative statement. So serial number 1, big fish, roe, borali, whole, not less than 1.5. Same thing, my lord. If my lord comes to column number 5, my lord, with the heading estimated rate, that is the threshold price, again mentioned, my lord. Threshold price is 715. Just right of that, my lord, is the petitioner's quoted price, my lord. Again, 715 rupees that we fixed. He has quoted 250. Next item, my lord, will come. Next item, my lord, medium, small, so and so. Our rate was 522. He has quoted 225. And but the other one, my lord, 1045. That was Magur whole mass, my lord. He has quoted 940. This is almost okay, my lord, 940. Then rest, my lord, our rate was 577. He has quoted 577. So for in respect of 2 items, my lord, his rate is, my lord, against 750, it is 250. Against 522, it is 225. In our understanding, my lord, it is not possible for him to supply. Some of the records, my lord, which doesn't form part of the petition, my lord. First page, my lord. This was a rate of items, my lord. This was the rate of items. Just a minute. Rate of items, my lord, submitted by GMC, my lord. We had on request obtained it from them, my lord. Second page, my lord, will kindly come, my lord. Serial number 10. According to GMC, my lord, big fish rate will be 400 to 800. Serial number 11. Medium small fish rate will be 400 to 500. Medium small so and so 500 to 600. And big fish 750 to 1150. My lord, to further fortify these calculations, my lord, we had constituted a committee, my lord, page 3. The committee submitted this, my lord. Heading, my lord, will kindly see market rate of the ration feed materials under Group D fish for zoo captives procured by the purchasing committee. Big fish, my lord, as against GMC, my lord. GMC's rate was, my lord, from 400 to 800. They have indicated 500. Next, my lord, medium, they have indicated against GMC was 400 to 500. They say 450. Big live big fish 750. GMC said, my lord, it is 500 to 750 to 1150. So there are two this type of, my lord, data we collected. Then what we did, my lord, to work out the threshold price, page 4, my lord. So these are the fishes, my lord, various fishes, agricultural. We have collected this GMC rate in rupees. These are the fifth column, my lord. These are the GMC rate, 6 column market survey. We have made a total average of both these items. Then, my lord, suppliers 10% profit we have assumed, my lord. So this is how, my lord, the threshold price was worked out. So against a threshold price of 715, they have quoted a price of 250, which is not possible for any party, my lord. Just to come out as a L1, my lord. If we allow them, as I have indicated, my lord, it will, the entire process will be, my lord.
Are we not living in a world of impossibilities and possibilities?
Possibilities will be, my lord, they can, in the name of local fish, they will be feeding,
No,
my
no,
lord, Salani fish.
You see, I'll just give an example. It may be inappropriate, but it's just an example
My lord.
to keep your mood lighter. You see, you catch hold of any officer of any multinational. For example, let us say Hindustan Lever, for price of any soap you like, go to Bata, ask them, ask any officer of this Bata, or say VIP luggage, and any brand you think of. And they'll tell you, we even have a lawyer, he now expired. When clients would come and say that for fees negotiation, he would also say that no, this is Kinadam, not below that.
Because he
No, I'm just telling you.
threshold bottom price, my
I'm
lord.
just telling you. So this Kinadam,
So that
concept.
nobody bargains beyond that, my lord.
Beyond that.
Below that, my lord.
yes. So that Kinadam concept, you compare it with something which is being supplied online, digital marketing, 2 or 3 brands, you'll find it low price. Even the managers, the what you call distributors, the company level here, they will say, I don't know how they give, but this at this price they cannot offer me a product.
Because these online things, my lord, they can skip many stages.
No,
my lord.
that I don't know.
Like a retailer,
No,
employees
no,
of
that
retailers.
I don't know. I don't know. But I'm saying that we are living in a world of possibilities and impossibilities. What the what you call the branch manager of the company says at Guwahati that he can't do it. Same company is selling it through another e-tailer at a lesser price. So I don't know. I'm not
Because they can
suggesting
skip
anything.
many stages, my lord. The
Yeah.
manufacturer directly sells to the buyer. So there are
I'm not
many
suggesting
stages.
anything.
They can skip, my lord.
I'm not suggesting anything, but
But in Assam, my lord, 250 rupees for a 1.5 kilo borali mas or roe mas local, impossible, my lord. Absolutely impossible. Even if the petitioner, he himself, my lord, is into fishing, my lord, fishery, my lord. He cannot, my lord.
I don't know. I have no personal knowledge.
That's why, my lord, I have tried to take your lordship to these data that we have collected.
Yes.
One data from GMC, one data from our own committee. We took an average of it, added 10%, then we fix the threshold price. From 715, the petitioner has quoted.
No, that what you see, when you have done so much of exercise, why not pen down in the contract that below this price would not be acceptable? Why that is not there?
That's why, my
you-
lord, I was trying to take help of that material deviation, my lord. To become responsiveness, my lord, there should not be material deviation. This much of price, it is true, my lord.
No, it's not there that we have not seen contracts like that.
It should have been indicated. True, my lord. It should have been indicated, but not indicated, my lord, we can take definitely recourse to material deviation. It will amount to material. Nobody can supply, my lord. Anyway, my lord, I'll take your lordship to now. Then my lord, from that bunch of documents, my lord will see page 5. Page 5, my lord. This is the minus of the meeting held on 29/5/2023 at so and so regarding this financial bid evaluation. I will see in the right hand column. Last column, my lord. MSDS Enterprise, respondent number 5, my lord. He's already out, my lord. He has quoted 65.7% less, my lord. Oasis Enterprise, the present petitioner has quoted 53.94%. Yasin is already out. The petition, the respondent number 6, my lord, has quoted 10% less than. So at 53.4% less price, my lord, it is not humanly possible to make supply of items who has to meet, my lord, food safety standards, my lord. Then, my lord, may kindly come to page 6, my lord. It's a statement prepared, my lord. Same thing in the table. Just bottom below the table, my lord, serial number 13. My lord will kindly see brief note on cross verification of evaluation sheet. As per the comparative statement, the number of participant bidders appeared 6 numbers. Out of 6 numbers, serial number 4 and 5 of the comparative statement are found not considered due to non-submission of required document by evaluation committee. C. On scrutiny of comparative statement, out of the rest of the 4 numbers of bidders, it appears that 3 bidders under serial number 1, 3, and 6 of the comparative statement offered bid value less than 65.7%, 40.07, and 53.94 respectively, which attract the condition outrightly rejection as laid down in office letter number so and so from additional PCCF headquarters and letter number so and so issued from additional PCCF headquarters, PCCF CEO Kempa. Then the name of the respondent number 6 was suggested. Now, if my lord kindly turns to the next page, my lord, page 7. There was a standing, my lord, order of the department regarding evaluation of bids. Page 7. I will like to take your lordship to page 9 of that bunch of documents. See, internal page 3, my lord. Serial number D. After the table, my lord. Page 9, my lord, of that bunch. Serial number D. The limit of financial bid evaluation shall be between -10 or +10 of the internal estimate. So bid value only in the range of so and so will be accepted. Any bid beyond this value,
Any statement,
it is
first of all,
not a part of the bidding document.
no, no, no. Is in the bidding document, is this referred to? This guideline, has it been referred to?
My lord,
In the bid document,
It is
is
not
this
reflected.
guideline referred to?
not
So
reflected.
there will be a hidden criteria.
My lord, then page 12 is the settlement order issued in favor of the respondent number 6. Page 12.
Just a minute.
In the comparative statement,
Just-
these two
just a-
communications are referred to while
No,
rejecting. my lord.
just a minute. The bid is invited by
DFO,
DFO.
my lord,
You know what is very interesting?
my lord,
Come to page 7, you are showing it to me.
70.
Only 7.
7
on
of
this
these
document,
documents. Yes, ma'am.
which you are referring to.
My lord.
Nobody deemed it appropriate to mark this to even a DFO.
Yes, my lord.
You have a wonderful guideline. Tendering it as authorities DFO, and you don't deem it proper to give it to them.
True, my lord. It's not marked with DF. Maybe the conservator of forest in turn has forwarded, but I don't know. I don't know, I cannot certainly submit, my lord. But it is addressed to all divisional forests, my lord. Page
At
7,
least it'll give you a satisfaction that the court has read.
my lord, page 7 itself, my lord, will kindly see it was addressed to all the divisional forests.
It's okay. I'm not making any comment. I'm just find an opportunity to smile, nothing more.
What I'm saying, my lord, that copy is not marked because the letter itself is addressed to DFO, my lord.
It's okay.
All DFOs.
Yes,
Next, my lord, may kindly pay to page 12, that's the final settlement order issued in favor of respondent number 6. Then page 15 is the security deposit receipt. And sorry, not 16, my lord, 15 is the receipt. Now, my lord, at page 16, there's a judgment. Of this honorable court. Page 16, my lord, almost identical situation arose, my lord. Very recent case, my lord. It will be relevant for this adjudication, my lord. Paragraph 2, my lord, at page 17. In this writ petition, the decision of technical evaluation committee to reject the price submitted by the writ petitioner by holding the same to be unrealistic and unreasonably low is under challenge. The fact and circumstances giving rise to the filing of this writ petition are briefly stated hereunder. The respondent number 4 had floated tender dated so and so inviting bids for execution of certain electrical works, the value of which was estimated at rupees 1.35 crores. In response to the tender notice dated 27/5/2022, the writ petitioner number 1 represented by the proprietor, that is writ petitioner number 2, and the respondent number 5 had submitted their bids. Their bids were evaluated in two parts, technical and financial. On opening of the tenders, the technical bids submitted by the writ petitioners and the respondent number 5 were found to be in order. After opening of the financial bid, it was found that the writ petitioner number 1 had quoted 11% below the PWD schedule of rate. I'd like to indicate one thing. This tender pertains to Assam Agriculture University, not PWD. After opening of the financial bids, it was found that the respondent number writ petitioner number 1 has quoted 11% below the PWD schedule of rate of 2013-14, whereas the respondent number 5 had quoted 5.12% below the schedule of rate. Therefore, the price bid of the writ petitioner was the lowest. However, after analyzing the offers, the technical evaluation committee found the order made by the writ petitioner number 1 to be unreasonably low. Accordingly, it had arrived at the impugned decision rejecting the financial bid of the writ petitioners. Consequently, recommendation was made to award the contract in favor of respondent number 5. The said decision is under challenge in this writ petition. By referring to the justification furnished by the technical evaluation committee in recommendation adopted in the meeting held on so and so, Mr. So and so submits that the impugned decision is entirely based on the circular dated 12/7/2018 issued by the government of Assam PWD. In that circular, it has been mentioned that rate quoted 10% beyond the PWD schedule of rate should not be accepted. Contending that the circular dated 12/7/2018 relates to civil works carried out by the PWD, whereas the present is electrical work. Mr. So and so has assailed the impugned decision of the technical evaluation committee by submitting that if the authorities had any doubt over the price quoted by the petitioners, then it was incumbent upon them to seek necessary clarification in the matter, in which event the petitioner would have provided proper justification. Referring to clause 40.1 and 40.2 of the tender document, Mr. So and so has forcefully argued that even in a case where abnormally low price is quoted, the authorities were under an obligation to call for a justification from the bidders, including detailed price analysis before taking a final decision in the matter. The same not having been done in this case, and the decision to reject the petitioner's financial bid having been taken merely on relying upon the circular of the PWD Assam, the respondents, according to so and so, has acted in illegal and arbitrary manner. According to so and so, the impugned decision is not only dehoves the law but is also against the public interest. Hence, same calls for an interference by this court. Responding to the above, Mr. So-and-so learned senior counsel has argued that reliance placed by the tender evaluation committee on the circular dated 12/2018 issued by the government of Assam PWD was by way of an additional support, but same was not the basis of the decision. According to Mr. So-and-so, clause 46.1 of the tender document makes it amply clear that it is not the L1 bid, but the bid which turns out to be the most advantageous to the employer will be accepted. Here also responsiveness is mentioned, ma'am. Mr. So-and-so has further argued that clause 40.2 relied upon by the petitioner's counsel would have no application in this case, since the same relates to only those bids which are found to be potentially low, but not the bids which are determined as abnormally low as per clause 40.1 of the tender document. Mr. So-and-so has further argued that the question as to whether the bidder was in a position to deliver the work and whether it has the ability to tender the goods and services by fulfilling the required norms of quality is a relevant factor for the employer to be considered at the time of awarding the contract. In support of his above argument, Mr. So-and-so has placed reliance on the decision of the Supreme Court in the case of Ronak International Limited versus IVR Construction Limited and others reported in so-and-so. Mr. So-and-so learned standing counsel AAU has, while supporting the submission of Mr. So-and-so, further submitted that the employer was well within its right to be vigilant about the freak rates, and if it is found that the tender is based on predatory pricing, it would be in the public interest for the authorities to reject such bids. Mr. So-and-so has relied upon the decision in the case of Jagdish Mandal versus State of Assam, reported in 2007, 14 SCC 517, to submit that unless there is arbitrariness in the decision-making process, the writ court would not interfere in a decision taken in the matter of award of government contract. I have considered the submissions made by the learned counsel for rival parties and have also gone through the materials available on record. At the very outset, it needs to be noted that as per clause 46.1, the tender document award of the contract was to be made in favor of the bidder who is determined to be the most advantageous as specified in ITB 42 clause 46.1 extracted herein below for ready reference. 46.1, subject to ITB 43, the employer shall award the contract to the successful bidder. It is the bidder whose bid has been determined to be the most advantageous bid as specified in ITB 42. Clause 42.1 defines most advantageous bidder. So these are quoted, my lord. In that case, my lord, it is true, my lord, it was the responsiveness or this, my lord, advantageous it was how to be worked out was specifically mentioned. But here also there is one power, my lord, that material deviation, my lord, it will amount. Anyway, next page, my lord. As per clause 40.1 of the tender document, an abnormally bid is one where the bid price in combination with other constituent elements of bid appear to be unreasonably low to the extent that the bid price raises material concern in respect of the capability of the bidder to perform the contract of the offered price. Clause 40.2 lays down the procedure to deal with which are identified as potentially low. That is quoted again. Next, my lord, a plain reading of the aforementioned clauses of the ITB make it amply clear that the tender conditions do not stipulate that the contract will be awarded in favor of L1 bidder, regardless of whether the price quoted by the bidder was found to be reasonable or not. Therefore, if the respondents have taken a view not to award the work to the petitioner number 1 by treating the price quoted by it to be unreasonably low, it cannot be said that the decision is towards the provisions of the ITB. The answer to the said question, in fact, of this case in view of clause 41 and 42.1 and 46, it obviously has to be in the negative. Then, my lord, Ronak International quoted page 9, internal page 9 at page 24 of last page of this bunch of documents, my lord. It is page 24, last page.
Still unable to accept this. You see, the para which you have, this page 7 or 10,
My lord,
the next para, plain reading of the so-and-so,
my lord,
and in the middle it says, firstly, clause 40.0
my lord,
does not refer to those bids which are already determined to be unreasonably low.
my lord.
The said clause in the tender document refers to only those bids which were deemed to be potentially low.
My lord.
So therefore, in the tender conditions, there was a
There was
clause of
specific- no dispute with that,
40.2. And then it says, this 40.2 is at page 6.
My lord,
It says in the event the identification of a potentially abnormally low,
my
the
lord.
employer, unless otherwise specified in the shall seek written clarification. So therefore, you see, under that circumstance, this court is holding that once it is already held to be dismissively low, then 40.2 is not applicable.
True.
But here you did not put them to notice.
Here, my lord, these clauses are not so specific. That's why, my lord, I'm trying to take recourse to that clause, page 45, 46, my lord, of the writ petition, my lord. Because this is alarmingly low, my lord.
In the forest department, whom do you consider to be a government?
Well, that's the secretary or commissioner secretary, man. We have also additional chief secretary. Man.
Okay.
My lord, page 45 of the writ petition, if my lord perishes once, my lord.
No. Come to this internal page 3
Of the judgment, my lord, that I'm
of the
relying.
judgment.
My lord.
Second paragraph.
By referring to the justification furnished by the Technical Evaluation Committee in its recommendation adopted in the meeting held on so-and-so, Mr. So-and-so submits that the impugned decision is purely based on a circular dated so-and-so issued by the government of Assam PWD. In that circular, it has been mentioned that red coated beyond 10%, quoted 10% beyond the PWD silver red should not be accepted.
You can stop for a moment here. Now this this page 7 you were referring to,
My lord,
this though it is made in the name of government of Assam, is issued by the additional principal chief conservator of forest.
my lord.
That is why I asked you this question. Who is the government for the?
It's a letterhead is my lord, government of Assam, but before that, below that, my lord, office of the PCCF, my lord.
Correct. No, that's what I'm saying. That's why I asked you that question. Who, according to you, is the government in the forest department?
Secretary onwards.
It will be secretary onwards. So therefore, this letter,
PCCF is my lord, directorate level post, my lord.
no, it's okay. But this additional principal PCCF,
My lord.
it does not become a government.
True, my lord.
Contrary to this, that is why I made you read this.
But all these tenders are not sent to government for approval, it is approved by the PCCF. Then settlement orders are issued by the DFO, my lord.
No, PWD tender is approved by the secretary. I don't know.
Chief engineer, my lord.
Chief engineer.
Chief engineer. There may be some breakup, my lord, depending on the volume of the work, but in this
No,
case,
that
my
is
lord,
different. But you see here the court is proceeding on a premise that the circular was by the government of Assam.
it is by the PCCF office, my lord. Because here, my lord, the tendering authority is DFO and approving authority is PCCF, my lord.
No, I am saying this because of a different reason. My question is, what you call, it's a manifestation of Article 13 of the Constitution. What is a law? Law will be act, rules and notifications. So if a government issues a notification, it becomes a law. But if it is not within the meaning of Article 13, then I'll find some difficulty in accepting that argument of
At least
yours.
it's a guideline for the authorities to follow.
No, I understand.
May not be as binding as a law, my lord.
Okay.
Because in this case, my lord, I'm referring to the judgment. There also, my lord, the authorities were guided by the PWD guideline. But that guidance they have taken, my lord, is not the sole criteria of rejection, my lord. In principle, PWD regulation was accepted, but on facts, they could find out, my lord, rates were so below. In 2022, the serial of rate was following up 2013 and 14. 10% below that is humanly impossible. Here is also is a case. It is true, my lord, in our tender, there is no whisper about this 10% thing, but we have actually not gone for that, particularly 10%. Had the petitioner quoted 12, 15, 20, that then also they could have get some consideration. But 60% below the rate, my lord. A piece of 700 rupees quoted as 250. We are worried about the quality of the work because tender condition also stipulates that they have to maintain the quality. They have to, my lord, maintain food safety rules, fresh fish. Only option
Well,
for them is to get, my lord,
incidentally, I'm not aware if to supply fish, you need a FSSAI codification. I don't know about that. Manufactured food, I understand. But to have an FSSAI compliant fish, I am not aware.
Life is. I think it is not required, or else my lord, this
I don't know. I am saying, you see,
formally had thing could not have come here, my lord.
everything I can't know. So I'll be dependent on you and Mr. Mahanto. But to understand that there is a fish with FSSAI compliant, I am really not aware.
But last page of this judgment, madam.
Yes.
Page 24 of the bunch, madam. Last page. madam. Second paragraph, it is a commonly known fact that the tendering authorities are often required to deal with freak pricing and the predatory pricing, whether bidders quote unreasonably low or high price, as the case may be, to break the contract and thereafter either commit default in execution of the work or end up delivering poor quality or claim price escalation way beyond the acceptable rate quoted by other bidders at the stage of submitting their bids. If the public interest is to be protected and the quality of the work is to be ensured, then the employers will have to guard against such predatory pricing policy. As long as the evaluation criteria adopted in such a case is transparent and consonant with the tender conditions, and the decision-making process does not suffer from the vice of arbitrariness, irrationality, and unreasonableness, the decision of the employer in such matter must be given due importance. The writ court cannot sit in an appeal over the decision of the employer in such matter. In view of that, what has been discussed above, this court is of the opinion that the respondents were well within their right and fully justified in evaluating the financial bid of the petition number 1 and coming to a conclusion that the price quoted by it is unreasonably low. Therefore, said exercise was not only transparent but also based on cogent materials available on record. So, my lord, to substantiate, my lord, page 45 for a moment, my lord, I have already taken your lordship there, my lord. Because it is true, my lord, there is no stipulation of 10% below, 10% above. But my lord, there are stipulations that they have to supply good quality. We have a clear picture about the market price and probability of the proper execution of the work. So I would, my lord, relying on this page, my lord, this clause at page 46 of the writ petition, my lord.
Just a moment.
My lord. Hearing that पूछो hearing that पूछो young men have been satisfied.
Yes,
Page 46 of the writ petition for a moment.
46.
The action that is under challenge, my lord, of my lord rejecting their bid for being quoting such a low price, my lord. And relying on this clause, my lord, 2.28.3. Because the price they have quoted, if it is accepted, my lord, a material deviation, reservation or omission is one that, if accepted, shall affect in any substantial way the scope, quality and performance of the subject matter of procurement specified in the bidding document. If we accept, my lord, this rate, my lord, it will affect our performance, his performance, my lord. That is the only clause I could find out, my lord, from which, my lord, it's a bit subjective, my lord, but our actions perhaps can be saved by this clause, my lord.
Okay,
I just give a reply, what my lord. I don't.
yes.
My lord, just quick
Actually,
reply,
wait, hold it.
reply.
Yes.
And my lord,
Reply at page 46.
well, let me conclude.
Oh, Mr. Mahanta is also to be heard. Then we'll take it up at 2 o'clock.
2 o'clock. I will hardly take 5 minutes, man, not more than that, man.
More than that, you have taken like a hearing.
We'll have to permit him.
Huh?
We'll have to permit him
Ah,
because in a
100%.
lighter note.
Ah.
He's having a particular addition to his name.
Oblige, man.
It's just in a lighter note. Just in a lighter note.
Oblige.
Sir, there, my lord, sometime, my lord, we are in the, my lord, the business is totally closed, my lord, in one case. One case, vehicle is there in the forest custody for last 4 years. My lord, with the concept of others, council, my lord, for other time, my lord, as you have, I pray, my lord, these matters today, it will take some time, my lord, it may not be. So 20th of July, my lord, both side agree, my lord.
July. Item number 20,
30 to 33.
32, 33. 0. 233. Okay.
Well, 20 well, July, 20th July. Much.
Wait, please, Your Lordship. That I beg to mention item number 53. Here in this case, my lord, my client is 80 plus and a compensation of rupees 9 lakhs, my lord, already ready to pay. Only thing is this, my lord, the government is to give a consent, approval to open a bank account by the deputy commissioner concerned, my lord. As the government is not giving this approval, my
At the
lord,
end of the day, before rising, I'll hear you.
it may be taken, my lord, before rising by your lordship.
Okay.
Oblige, your lordship.
No, please, your lord. My lord, supply item number 75, lord. We filed an IA, lordship. It will be taken up on Monday, lordship.
75.
75, lord.
What is this I for?
My lord, it is for, my lord, modification of the interim order, my lord, for a slight modification, lord.
Tuesday.
Lord. Deeply obliged. My lord, one paragraph from it has been, madam. 2007-14 SCC.
Two 2014.
2007, volume 14. Page 517.
2007, 14 SCC.
Page 517. That same Jagdish Mandal case, madam, para 33.
Yes.
Para 33, the fifth respondent had submitted an unduly low rate in regard to item number 19, CC lining. It was the last item of the work to be executed. And constituted nearly 1/5 of the total estimated cost value of the work. In regard to the said work, as such, the rate of rupees 2020.50 per cubic meter estimated by the department, the fifth respondent quoted an absurdly low rate of rupees 20, only which was less than 1% of the estimated rate. It is obvious that he could not have executed the work at that rate. The CC lining being the last work, there was every likelihood of the tenderer executing other items of the work for which he had quoted much higher rates than others and leave out of the last item and raise some dispute, thereby jeopardizing the work and cause the delay. It is true that a contractor could have an answer by contending that he had priced the other items of the work in a manner which enabled him to quote a fairly low rate of the one of the items. But then the committee is entitled to consider the effect of such freak rates, where the absolutely low rate is in regard to a large item of work which has to be executed at the very end. It is possible for the committee to suspect some ulterior motive on the part of the tenderer. If the committee felt that there was a reasonable possibility of the contractor leaving the work midway on account of the rate quoted for the last item of the work being found to be unworkable, thereby putting the work in jeopardy, it can certainly reject the tender as it affects the reliability of the contractor to perform the work. Unduly low and unworkable rate or rates is a ground for rejection of tenders, right? Note number so and so. Here, madam, this specific clause is not there, but material deviation is there, madam. The modus operandi of quoting low rate is in regard to some item of work and thereby securing the contract and then raising dispute by making large claims is not uncommon among the contractors. The very purpose of constituting a committee for scrutinizing the tenders is to find out whether any freak low rate will affect the work if the contract is awarded to the tenderer. If the committee found that the tender of the fifth respondent should be rejected on that ground, the said decision cannot be termed as unreasonable or arbitrary. The committee has applied its mind and rejected the tender by assigning a reason which is neither irrational nor arbitrary. Neither the High Court nor this court can sit in appeal over such technical assessment. There is no infirmity in the decision-making process or the decision. My lord, may also take note of paragraph 20 to my lord is available. This was again and again placed, my lord. Regarding, my lord, even the principles of paragraph 22, it says, my lord, the principles of equity and natural justice stay at a distance in respect of commercial transaction, my lord. And even that principle is also applies when considering for passing an interim order, my lord. Then, my lord, there are two judgments. I will not trouble your lordship. Just I will, my lord, may just record it, my lord. 2020, volume 16 SCC. Page 759.
Para,
Para, my lord, 29 to 35. That Bharat cooking coal, my lord. Then 2022, volume 6 SCC.
2000,
22, volume 6, SCC 127. Paras would be, my lord, 1 to 15 and, sorry, 10 to 15, 17, 21 and 23. My lord, just last concluding at this point, my lord. My lord, this tender, my lord, was floated in tune with, my lord, if my lord peruses page 31 of the writ petition for a moment, my lord. This tender is floated, my lord, in tune with Assam Public Procurement Act 2017 and the rules framed thereunder of 2020, my lord. Page 31 of the writ petition for a moment, my lord. This is the NIT, my lord. Page 31, last clause, my lord. Last clause, the bidder who seek to appeal against any decision, action or omission regarding this particular procurement may do so as per section 38 of the Assam Public Procurement Act and the rules, rule 26 of the Assam Public Procurement Rule 2020. The first and second appellate authority are as mentioned below. So there is a statutory appeal provided under the Act and the rules, my lord. And interestingly, my lord, it is not only rule 30, section 38 that provides the scope of appeal against such decision, my lord. Section 39 of that also, my lord, empowers these authorities, first appellate and second appellate authorities to pass interim orders, my lord. Section 38 and 39. So that is a efficacious remedy already available to the petitioners, my lord.
with that,
38 and 39. Thirty-nine is relevant, my lord. That makes it more efficacious, my lord. Thirty-nine says, my lord, while hearing an appeal under section 38, the officer or authority hearing the appeal may, on an application made in this behalf, and after affording a reasonable opportunity of hearing to the parties concerned, stay the procurement proceedings pending disposal of the appeal if he or it is satisfied that failure to do so is likely to lead to miscarriage of justice. So instead of preferring this writ petition, my lord, the petitioner could have also approached this statutory appellate forum, my lord, which is already indicated in the NIT.
You just take this book. My court master has given me one. I have a question to ask you. Please,
Page number.
279. This, you have to show me that fish falls within this item. 2O, goods,
2O in definition, my lord.
yes.
Goods includes all articles, materials, commodities, electricity, livestock, furniture, fixtures, raw material, spare, instruments, software, machinery, equipment, industrial plant, vehicle, aircraft, ships, railway, rolling stock, and any other category of goods, whether in solid or liquid or gaseous form, purchased or otherwise acquired for the use of a procuring entity as well as services and works incidental to supply of goods, if the value of such service or goods or both does not exceed that of the goods themselves.
And ZB is services.
ZD, my lord. Works. Work means works associated with the construction of reconstruction.
Because it will show us that these goods and services which are procurable, this fish will fall within the meaning of this Assam Public Procurement
Yes,
Act.
if we go to the definition of goods, my lord, definition of goods includes
All articles.
all articles, materials, commodities, electricity, livestock, furniture, fixture, raw materials, spares, instruments, software, machinery, equipment, industrial plant, vehicle, aircraft, ships, railway, rolling rock, and
is not
any
a-
other category of goods, my lord. That will include this one. And any other category of goods. And NIT also, my lord, makes a reference, my lord. That same page, clause number 2. Page 31, clause number 2. Open competitive bidding method shall be followed for selection of most preferred bidder for the tendered item. The tender items, conditions and procurement are in conformity with the Assam Public Procurement
Oh,
Act.
acha.
And the rules. So that
Okay.
any other goods might include, my lord, these goods also. And to conclude, my lord, what the difficulty that we are facing, my lord, in 2018-19, there was a bidding process initiated by JU, my lord, for procuring these supply materials. There was an interference by this honorable court on the ground that there was no schedule of rate, whereas schedule of rates formed part of that writ proceeding, my lord. And accordingly, this honorable court directed us to go for fresh tender in all items. This is one of the items, my lord. There are several items. So when we could find out, my lord, that schedule of rate was already a part of the proceedings, we preferred around 9 review petitions, my lord. All review petitions were heard in 2021, I suppose, my lord. Yet are already reserved for judgment. Judgment is not yet delivered. Under that circumstances, my lord, for 2022-23, for only one item, we floated another tender, my lord. Then this honorable court, my lord, allowed us to, that was also challenged, my lord. Then this honorable court allowed us to go for that particular tender. So this is the first time, my lord, since 2018, we are going for fresh tender. Otherwise, my lord, all these procurements are made on private basis. My lord, that is a heavy burden on the exchequer, man. This is the last order, my lord, in 2022. That gives the background story, my lord. Paragraph 5, if my lord peruses. Paragraph 5, my lord. It's the background, my lord. In pursuance to the tender notice dated 26/5/2007, by which the tenderer were asked to submit their tender for supply of goods of foodstuff of Jew captive for the year 17-18 under Group A to P. Here, my lord, Group D, that was A to P, all the groups. The petitioner was selected as a successful tenderer for Group O. Thereafter, in the next year, the state respondent issued another tender notice for supplying ration and materials on Jew captive for the year 18-19. However, the tender notice dated 27/7/18 was cancelled due to technical reasons. Fight notice dated 12/10/2018. Being agreed by the cancellation of the tender notice dated 27/7/18, a number of persons, including the petitioner herein, challenged the notice dated 12/10/2018 in various writ petitions. The leading case being WPC so-and-so. The bunch of writ petitions led by so-and-so was disposed of by this court. Fight order dated 4/6/2019, wherein it set aside the notice dated so-and-so and directed the state respondents to finalize the tender in terms of NIT dated 27/7/2018. The notice dated 12/10/2018 had been set aside by this court primarily on the ground that there was no seal of rate fixed by the state respondents while calling for tenders. Being agreed, the state respondents preferred various review petitions challenging the judgment in so-and-so on the ground that the seal of rate was already in the records of the writ petition, especially in the affidavits filed with the state respondents. The review petitions are numbered from so-and-so. The review petitions were reserved for judgment by order dated 9/2/2022. Until date, no decision has been made on the review petitions. Consequent to the above fact, the quotation notice dated, this was the last matter, 11/11/2022 had been issued by the state respondent asking for quotation for supply of foodstuff of Jew captives for the year 22 under Group A, only one group, my lord. It is also an admitted fact that subsequent to the year 2017-18, the persons who are supplying foodstuff to the Jew captives till date have not been selected on the basis of any tender process, and that those persons, including the petitioner, are supplying foodstuff to the Jew captives for last 4 years on private basis. This private arrangement of supplying foodstuff without going through a tender process does not appear to be proper in as much as public money involved in procuring foodstuff is involved in procuring foodstuff. Further, the issue in the earlier writ petition and in the review petitions was with regard to the tender for supplying of foodstuff to the Jew captives for the year 18-19 only. It has nothing to do with the supply of foodstuff for the year so-and-so. Due to the reasons stated above, this court is of the view that tender process should be allowed to continue as so-and-so has stated petitioner we allowed them to participate after the. So basically, my lord, since 2018, my lord, we are purchasing on private basis, and these funds are basically sent from Central Jew Authority, and they are consistently insisting that we should go for tender. That will be all, my lord.
Yes, Mr. Mondo.
I just to have a appearance before court number 12 for 5 minutes. I will be back now.
Actually, my lord, to speak the truth, I am totally handicapped. Because after getting the final order, I filed a caveat yesterday. So which was brought, my lord. And today morning I asked for a copy, although it was asked, my lord, it was not provided to me. So what are the material available to me? I will make case, my lord. I have not received copy till.
The copy
Why,
they
sir?
have filed a caveat. No, caveat has been filed tomorrow.
No,
We
no, I
filed day before yesterday we filed. Caveat because your lordship will kindly see one thing. Well, I am not like that I am not a survey copy. What has been done by the department? With great regret, I have to say, my lord. Yesterday, day before yesterday, we moved the matter. Now tomorrow, my lord, matter is will, but somehow there are so many cases. It has been listed today. What they have done, my lord, tomorrow itself, yesterday, what they have done, the earlier some tenderers, some contractors they were running, they have cancelled it, what we have come to know, and the award was given to my learned friend's client.
No, it's okay,
After
but
filing
once he is
the-
appeared, he is entitled to a copy.
No,
It is a copy.
absolutely, there is no bar of giving a copy, my lord. My learned friend is the beneficiary of the contract. He'll be beneficiary of the contract. He has got every right. But how a contract has been given is a government who has given the contract. The copy में दे देना, क्यों नहीं दियो copy है? अरे copy दे देना. दे दे, क्यों नहीं दियो copy? Copy दिखो लगे तो more.
My lord, my final settlement order was passed, my lord, on 21st, my lord. After depositing, my lord, I was asked to deposit, my lord, performance security, my lord. And I was asked to sign the agreement, my lord. After that, my lord, final settlement order was passed. A contact was, my lord, It is started from 23rd June, that meaning today, my lord. So I deposit everything, and today I supplied, my lord, the fees as required, my lord. That is today I have supplied, my lord. So regarding, my lord, law point and everything, my lord, my learned friend already elaborately, my lord, explained before your lordship everything, my lord. One thing I am submitting, my lord, your lordship kindly show material which was available with me, my lord. So, my lord, your lordship kindly see is rate quoted by my learned friend client. It is exorbitantly low, my lord. Exorbitantly low, and my rate just to, my lord, became a L1. If you put a exorbitantly low authority, my lord, under the, my lord, facts and circumstances, it is not bound to accept it, my lord. Your lordship kindly see the official rate, my lord, is above 700. Now he has quoted, my lord, 250, even a 1.5 kg fish, my lord. Quarterly fish, my lord, it cannot be a, my lord, getting in 250 rupees, my lord. None, now nowhere in Assam, my lord. You have either you have to compromise with the size, because that it cannot be lower than 1.5 kg, my lord. So now that is why, my lord, it is absolutely impossible, my lord. So my quotation, my tender value is, my lord, it is 10% of the, it is considerably low, my lord, it is 10%. Usually, my lord, all the department, my lord, 10% low is, my lord, participate. But 53% low is, my lord, then the prescribed rate is, my lord, quite impossible. So, my lord, while deciding this, my lord, while deciding this process, my lord, there is no arbitrary and there is no malafide, my lord. The normal procedure was, even in the forest department, in their plantation, my lord, in that there's a circular, probably my learned friend is placed before your lordship, that up to 10% it is permissible. So, but 50% is, my lord, quite impossible, my lord. That's why, my lord, while they are taking a decision to give the contact award to me, my lord, there is no arbitrary, then there is no malafide. And, my lord, regarding, my lord, I have already supplied the fish, because we cannot keep, the authority cannot keep the, my lord, their hunger, that birds and animal who eat fish, my lord. And today morning I have supplied, my lord. That is the document here, my lord. So balance and convenience also in my favor, my lord. That's why I'm submitting before your lordship. Yes, matter may be examined, my lord. But so far is, my lord, question of stay is concerned, my lord. That final order, which was not been also, of course, it is not been salient, my lord. So I have already deposited the with security. I have already taken over, and I have already supplied the materials. Probably that my final order has been placed before your lordship. Otherwise, my lord. There is a final order of settlement,
Oh, no, we have it.
my lord. So yes, my lord, already my learned friend, my lord, departmental advocate, my lord, who will respond it, my lord, and they have already, I adopted the argument made by him. But just I wanted to do, my lord, place before your lordship that I have taken over, and I have already, my lord, supply has been made today, my lord. That's.
Yes, Mr. Das.
I'll just give a reply, quick reply, my lord. I think all my learned friend, additional AG has argued, these are all fallacious, because kindly see, first, I'll just give you a reply to what he said about determination of reserve responsiveness at page 45. He read only 2.28.3 at page 46. Thereafter, he has not read at page 46. This responsiveness only will be in respect of technical bit. Kindly see, my lord. 2.28.4. The bid evaluation committee shall examine the technical aspect of bid to confirm that all requirement of bidding document had been met without any material deviation, reservation, omission. It is only in examination of technical bid. So there is nothing to do on final. Further, I will submit before your lordship. Kindly see 2.28.5. The bid 2.28.5. The bid evaluation committee shall regard a bid a responsible if it conform to all the requirements set out in the bidding documents or depart from the characteristic terms and conditions. Other requirements set out in bidding document, that is, there is no material deviation, or if it contains error or oversight, can be corrected without any change in substance of the bid. It cannot be, my lord, in respect of a price bid. Kindly see now 2.28.6. Bids that are not responsive or contain any material deviation shall be rejected. Bids declared as non-responsive shall be excluded from any further evaluation. That is a final evaluation, my lord. Financial evaluation. So when at page 88, I along with my learned friends client and along 88, technical bid was examined. So there was no material deviation. How my learned friend can now argue and say that we have examined, material deviation will be not in respect of a price bid. So it is very clear. This is one, my lord. Second, page 58, very limited, my lord. 2 minutes I will take. 58. Kindly see page 58. Roman 10. Roman 10. 58 Roman 10.
Yes,
The rates offered should not be more than the threshold price of the individual item fixed by due authority. If the rates are more than threshold price for any of the items listed so the bid shall be rejected. So, my lord, it is not a case that within 10% or less than 10%, that is not there in the bid. And I'll show my learned friend document, how they have highlighted. Kindly see now, which my document, my learned friend has shown the documents to your lordship at page 9. Kindly say page 9. There are guidelines. Kindly see page 9. Kindly see page 9. Criteria for bid evaluation. Lordship got it? Criteria for bid evaluation as per the state government norms, the work contract shall be evaluated as per least cost method. The following eligible criteria has to be fulfilled by the bidders for the pursuant. So, see, my lord, kindly see D now. D. The limit for financial bid value shall be between minus 10% to plus 10% of the internal estimate. So bid value only in the range of 10% below to 10% above estimated cost will be accepted. Any bid beyond above said limit shall be outright rejected at time of opening of the financial bid. Accepted. Now kindly turn to page 10 H. Kindly turn to page H. Next page at page 10 H. Point number HA to 8G should be inserted in the tender document by tender calling authorities at appropriate pace. So point HA to 8G, kindly see, this is Roman 2, minus, sorry, Roman 2A to Roman 2G. Lordship got it? A to G. So if it is 10% minus or plus, which my learned friend AG has shown that addition is a 10%, which my learned friend has said, that has to be inserted, which your lordship was asking, whether it is a part of terms of the contract or not. My lord, I'll give at loss. What is the problem? Now, what your lordship pertinent, are very pertinent, whether there is any clause of penalty or not. They find a substandard they will give a notice, blacklist me from that. My lord, I also know, my lord, your lordship may not be aware what is, how a fish in the market. No, what I'm saying, my learned friend has said, I also am aware of what is fish, my lord. My lord will kindly see one thing, my lord, then I will close it. I'll close that, my lord, kindly see. That is not the area where your lordship will look into it, but I'll just tell your lordship. Kindly see the comparative statement at page 92. Now kindly see one at page, very interesting, 92, kindly see one.
At least, Mr. Mahanto, price of fish does not rise because of me. Since I'm a vegetarian,
My lord,
since
yes,
I'm a vegetarian,
my lord, one
price of
matter,
fish does not
one,
rise because of me.
my lord, one case I remember, this went to Supreme Court in 2004, Jasper Icelong versus State of Meghalaya. This, what has happened, it traveled to Supreme Court. I was there. Prices of the coal may vary. Public interest is to be looked. The Supreme Court said a prudent businessman know what is the price. He may give lot of price. Because when it is case of a price which is to be quoted by me, my lord, and I have to pay to the government, highest has to be done. And when it comes to a government to give it to a particular bidder, then the lowest has to be quoted. Now, what is the price? Kindly see one, big fish, lordship, kindly see at page 92, one, big fish, bracket, rahu, comma, borali, comma, sole, not less than 1.5 kg. It is not talking about rohu, it is talking about borali, it's talking about sole. And what is this? My lord, these are not a live fish from Brahmaputra. This is at 3, kindly see. That's why I checked, my lord. Kindly see 3 live big fish. So what is the rate they have given? My lord, 1045 estimated. What is the rate I have quoted? 940. So if you want to buy a live fish from Brahmaputra, my lord, if it is 1045 estimated, the rate which is given 940. If I want to buy an Andhra fish, these are Andhra fish 1. So Lucknow fish, these are always, my lord, it will not go so high as like a live fish from Brahmaputra. So, my lord, these are exactly what we have, we know the price. And see, kindly see, exorbitant price, my 1 crore 52. And my lord, can it be a subjective satisfaction? They are speculating. It is not possible. How it is possible that I will supply? I cannot supply with that rate. It is my prerogative. I'll supply. Absolutely no problem. I will not compromise with the quality of the fish. You should be concerned about your money. This is what I'll argue, my lord. What my learned friend is saying, speculation. Can it be a speculation? Otherwise, your lordship is right. If it is under procurement, you prefer, don't call for a tender. Why you have called for tender? And lordship has seen, particularly this, nowhere in the tender condition speaks about 10% minus or 10% above. This is only what the criteria is, threshold price. It should not be more than the threshold price. You cannot settle, my lord. This is what you have done. And kindly see at page 93, what you have, how you have awarded a contract. See 98, my lord. Lowest bidder. Can it be termed as the lowest bidder? You are L4. You are not a lowest bidder. So the terms and condition has been violated. And so far as the provision of appeal is concerned, my lord, your lordship, I have checked. At the words that particular goods I have checked, my lord. Nowhere it is mentioned. This falls within this criteria. And
No,
secondly, my lord,
but this tender conditions itself says that.
no, maybe, but in all the tenders, my lord, these are always, it is, but my lord, they have to strictly comply with those terms and conditions. Those terms and conditions has to be strictly complied. When it is arbitrary, when it is nullified, why the High Court or 226 cannot interfere, my lord? What about those cases, my lord? There are now numerous of cases. It's arbitrary, principle of natural justice not followed. Without jury, how they can, my lord? Yes, of course, your lordship can interfere it. There are so many cases your lordship is dealing. Those cases in a contractual matter. And those cases which my learned friend has shown that Jagdish Mandal cases, my lord, facts of the case has to be looked into it. What is the facts of this case? Those facts that you have to see, my lord, what is the terms and condition of those bids? Terms and condition is before your lordship. What is the terms and condition in this particular case? So my humble submission before your lordship is that it is a case, prima facie there is a case. And the balance of convenience in one day, it has been done on 23rd. Kindly see the order. They were so hurried, they know a writ petition has been filed by us. And the government was so hurried to give this contract to the private party. That is why they said 23rd of June, it has been supplied. Kindly see. And we have given the copy day before yesterday to the government. They know, my lord. That's the whole problem. They know it. And my humble submission, my lord, this order should be, and my learned friend has said that I have not challenged it. Kindly see the prayer in my writ petition, my lord. Kindly see the prayer. What was it? My lord, 27, 28, kindly see, my lord. My prayer. Stay, suspend the operation notice, stay, suspend. Now 4, stay, suspend the operation next 28. Stay, suspend the operation of any consequent order issued to respondent 6 or agreement entered with respondent 6 by so and so. Any consequent, we know, my lord, this will happen. That's why we have inserted the prayer. That's my humble submission. Your lordship will kindly interfere it. And this particular order should be stayed. And in the meantime, if the Jew authority want to, my lord, go ahead, they can go ahead and they can supply of their own. It's a matter of 2-3 days. And if that be the case, interim arrangement of the amount which we have quoted, that we should be allowed to continue till the lordship doesn't decide the matter. Because our rate is a rate where the government will not lose. Because my rate which is given. So in the interim, we should be allowed to continue. Like a temporary settlement in fishery case. We should be allowed to continue. There will be no loss to the government. And giving money to us will be lower rate. And if they find, your lordship can note also, if they find a substandard, they can chuck out from us, my lord, from this entire bidding process. We should continue, my lord. Because apparently on the face of it, our rate is much more lower than the rate which my learned friend's client has quoted. That's my humble submission before you. Deeply obliged.
Okay, let me examine past orders. The orders will find it on Monday. But today it's not be possible for me to dictate and transcribe and make it online.
I'm deeply obliged. There is one election matter, my lord. But I think item number
After the
77.
motions, I will call it up.
Yes.
My lord, in lighter sense, my lord, I am submitting of the record. Mr. KP Pathak, senior advocate, he is watching this, my lord. He says, nobody can say except me the price of the my lord market. But he is a very regular visitor to the all market, my lord. I say that you next time go that forest department will take help of you. But must be.
Well, but there's another lighter tone of it.
My lord.
There's another lighter tone of it. Today, even a vegetarian will know a price
Yes,
of the
my
fish.
lord. No, okay, that vegetarian in this part.
Incidentally,
Fish, my lord, fish
No, no.
nowadays.
no, incidentally, I was just searching for
Right.
the price of fish. And in the internet, the price of one of that item was there, Rohu, ROHU, fish.
Hmm.
In Andhra Pradesh, it is 720.
Andhra Pradesh.
Andhra Pradesh, my lord, they, when they supply here, my lord, is very, very low rate it is supplied.
No, I
We'll
don't know,
get
but
it-
here it is given
No,
720.
it is very low.
But here in
This
local
is
sales
frozen.
are high.
It comes, my lord, it comes frozen here. And there it's, my lord, it comes frozen.
No, I was comparing your rate
Yes, yes.
Yes.
compared to the rate. Your rate is still lower than what is available in Andhra.
Yes.
My lord.
Nowadays, my lord, fish has become expensive also. I'm not saying local fish, live local fish. By you, my lord, what they do, normally they pick up. If your lordship goes morning walk, then you see that there is what they do, they pick up as a whole. Wholesome they pick
No, I
up.
don't know,
The
but
rate is good.
here I even saw the local people were telling us that they even catch Andhra fish in the Brahmaputra and bring it and give it to the
Exactly, my lord.
during Bihu and Puja.
And they
They
put it in
catch
the, put it in
and-
the boat, my lord, and went to the, my lord, other side and came back from, and then they sell it in the Kasari Bazaar, my lord.
But that is why somebody was telling me there.
But
that
my
they-
lord, who is expert in fish, 1 second they can say
Yes.
that whether is Andhra or local.
And-
At least I can say that, my lord.
He-
Whether local
Yes,
or
my lord.
Andhra.
He knows, my lord.
Okay, my lord.
Must be.
Deeply obliged.
Yeah, this is 17.
May I please, your lordship? My lord, the
Okay,
petitioner's
ex gratia.
brother, my lord,
Okay.
was killed.
Heard Mr. AF
Can you?
NU Mola, counsel for the petitioner, and Ms. M. Burman and the government advocate appearing for you're appearing for all?
1, 3, 4, 5. 2 is type.
One, 1, 3, 4, 1, 3, 4, 5. No, 4 also finance. They will go 1, 3 and
1, 3,
1,
5
3,
and 6.
5 and 6.
Finance is.
Relief and rehabilitation is by finance.
No, my lord, it's revenue. But they have not written revenue. 4 is finance, my lord. Please take my notice.
2 you are
I-
appearing,
I-
Ms. Ashutia, standing counsel for,
My lord, I am appearing on behalf of P Nayak.
Learned counsel appearing on behalf of Mr. P. Nayak, standing counsel for revenue, then revenue department. Finance will be also you,
Yes, sir. Finance, my lord.
finance, so 2 and 4. Next one. Giving non-receipt of ex gratia on account of death of one Tika Maya Devi. Deceased is Tika Maya Devi.
No, my lord.
Who is the deceased?
This is one, Ganesh Shyam. Dahal.
Ganesh Shyam Dahal, GANESS, Ganesh Shyam Dahal, DAHAL. Killing of Ganesh Shyam Dahal by extremists during 2000. The present writ petition has been filed under Article 226 of the Constitution of India. Issue notice returnable in 4 weeks. Requisite extra copies of the writ petition be served on the state and departmental council in course of the day. Where is the FIR?
FIR is not here, my lord. It's the old case, my lord. Now, my lord, we have annexed here, page 18, 19, my lord, sanction order. Page 19, my lord.
Okay.
It is just-
despite, you see that non-payment of ex gratia despite sanction order dated 21/8/2000.
By this 1 lakh was paid. Now additional ex gratia for rupees 2 lakhs. Now additional ex gratia of rupees 2 lakhs.
Where is that?
Well, this is page 19, my lord. Earlier 1 lakh was received, my lord. And
Okay.
now, my lord, as per notification, kindly see page 33, 34. This is the memorandum, my lord.
You will not get it as per this.
34, my lord.
No. What is the policy at that point of time?
No, subsequently, my lord, it was, my lord.
No, subsequently, you see, after 10 years, they can increase it to 10 lakh rupees. Again, you will, whether you will get it again.
That has been given because service policy was there and that was repealed, my lord. Then this amount was, my lord, given, my lord. But that service policy was, my lord, repealed. Instead of that, my lord, now 2 lakhs has been given additional. This is page 34, last paragraph, my lord.
34.
34. In case of persons, my lord, last. Page 23, more clear, man. Page 23.
Where is that notification?
Page 23, my lord.
23.
23, my lord. Serial number 3, my lord. Enhancement fund.
Okay, you just said then write it differently. The brother of the petitioner, namely so and so, was killed by extremists in the year 2000. So, there is no dispute that as per the scheme that was prevailing at that point of time, compensation to the extent of rupees 1 lakh as applicable was paid to the petitioner. First of all, it is projected that by subsequent notification dated 22/6/2004 within bracket annexure 3, the earlier applicable Assam Public Services within bracket, appointment of family members of persons killed by extremists, public terrorists, bracket closed, rules, 1992 was repealed. And by the said notification dated 22/6/2004, the ex gratia paid to the next of kin of person killed in extremist violence was enhanced to ₹3 lakh. Accordingly, the petitioner has filed this writ petition on Article 226 of the Constitution of India, seeking enhanced compensation. We issue notice, extra copies. Pendency of the writ petition shall not be barred for the respondent authorities to examine the claim of the petitioner and to release enhanced compensation if annex ex gratia if found due.
Deeply obliged.
19,
Name of the SC revenue may be reflected in the copy.
Okay, so it will reflect the name of
SC.
the SC revenue. Well, listen to the matter next.
Give to place.
I just went outside with Mr. Monto and checked about that fish price where your lordship Andhra fish. I was a bit of doubt because I know because Andhra fish, we have checked 800 minimum per quintal. Per quintal, mile. And there is one boat. We have seen a boat, Assam fish, 300 rupees. And Andhra fish, 160. There is a boat called National Ministry of Fishery Animal Husbandry is National Fishery Development Board. Here your lordship will find all the rate. I told Monto.
May I please your lordship?
Just a moment. This is item 19.
Lordship, I am on behalf of MU Mandal.
Yes,
Lordship, please pass over the matter for the company.
for the time being.
Obliged.
20,
Your petition cannot be allowed. Your petition cannot be allowed. You see, in the RTI reply, they are saying that the map is not available. And you are saying it is absurd.
Because it can also be provided from the records available with the circle officers, from the Jama Abandi records. That is available with the circle officer.
According to you, Jamandi, what you call
Yes.
register will have map.
We are not seeking map. Also, we are not seeking the map actually also. We are seeking what are the new ducts and patta numbers also. They are saying that it is the Vendic map is.
No,
not
just tell me one more thing.
available.
Now, this certified copy of Chitta, or sorry, this certified copy of Jamandi, can you not apply and get it?
No, they have created some new.
It's
So-
okay. I understand they have created something new. But let us say a judgment of this court or an order of this court.
Okay.
You are wanting to get it by way of an RTI. My question is that if any public record
2020.
for which certified copies are issued under 76 or 78 of the Evidence Act can be applied and received. Can you be given that document by way of an RTI? Let us see, because you see, it's a loss of revenue. Even 1 rupee 10 paisa, which is required to be paid for that certified copy, is a revenue loss to the authorities.
But also the Assam Information Commission has already passed an order in this regard also.
No, you see, I'm not saying anything else. Two things
Despite
I have
that-
found. Number one, it says that the copy is not available. Map is not available. That is the stand taken. You say that is absurd. Now, please tell me how it can be an absurd proposition that the map is missing for some reason. You see, for example, Kamakhya, the land, the entire land records are missing. A place like Kamakhya Devalaya, the land records are missing. I know it because I have dealt it on judicial side.
What's our,
And
our queries-
because of that, this court has issued a direction not to issue copies to anyone. because they are all manufactured copies and they are circulating. Without being the original, duplicate certificate copies are now being issued. So therefore, this court has stayed issuance of copies of land of Kamakya Devalaya.
Lordship, the information we have sought for, Lordship, at page 16. Simple, how many and what new dag and patterns have been created?
You can just
For
get a
the court-
certified copy. What is preventing you from getting it? Nowadays, this certified copy of
They are
Jamabandi
not providing it. That is why, Lordship, we have opted for
is
RTI.
online. Everything is online.
No, it is not there. Lordship. Otherwise, Lordship, we could have obtained those.
You just get the information.
Right.
This land reference is there.
My
Just ask your deputy commissioner's office of the particular place.
lord.
If this information is available in the portal to get copies. Now you have to apply online for the,
Whether it is notified service or not.
no. You see, Jamabandi of anybody's land can be obtained.
Definitely,
The information what we want is that data
yes,
available in the public domain.
my lord.
So if it is available, if he wants it,
can
he will
get
get it. Only that much.
Our questionnaire was, Lordship, what are the new dag and patterns pertaining to old dag number 2 and 1635? That simple information, Lordship, we wanted, Lordship. For that, Lordship, we have moved the first appeal, second appeal, but they are not providing this information. Lordship. Otherwise, Lordship, we could have obtained a certificate copy of the Jamabandi.
You see, for that I can't help you. The simple reason is that if you know the dag number and go to the chitta, you will get it. To obtain information as to how many dag have been carved out
Yes.
from one
new
of the patta land, you have to just go and visit the mandal, get the chitta, and you will get it.
Lordship, we are not getting this thing. That is why, Lordship, we have, otherwise, Lordship,
No, it's okay. Let us get the information. Well, it's available through a certificate copy. So why an RTI?
Lordship
Based
will
on
fix it.
Wednesday,
Wednesday.
less than so, all sides are duly presented, less than so. Just to enable the employment and government advocate to obtain information as to whether the relevant information of the land revenue records are in public domain. Just to obtain certified copies of the same. Correct? Just get the information. I'll take a break and come back.
Obliged.
No objection because, my lord, they do not fall within the purview. Their business is totally different. They are running illegal business, even though, my lord, 302 is going on against them. That I'll reply afterwards, my lord. If your lordship take up the writ petition, my lord.
No, just a moment.
Yellow order to Udayan. Yeah.
Where is that application?
I what
My
it
lord,
was,
they have
I
no locus also.
23.
That's okay. Unless I look at the petition, I can't say anything. In a writ petition, when an application for implementing is there, I have to attend that first.
My lord, because what happened, my lord, what is my objection to that, my lord?
No, you may have a valid ground. I am not discounting any of your statement.
Yes.
But the fact is, you tell me the law. If there is an application for implementing pending in a matter, I should hear the writ petition first or the interrogatory application first. What according to you is the law?
Kindly hear the interrogative application, let them show the locus standing.
It is available here? No.
It's there, minus number IA 1819. It's shown in the.
1819.
What is it?
Yes, what is your ground?
My lord, actually, my lord, we are the cabineers, my lord. They are the tourist guide, my lord, and engaged in the promotion and upliftment of the environment and the atmosphere, my lord, in the Dibu National Park and the more particularly Marguri,
Gogoi, is he here?
Madhapur wetland.
Mr. Gogoi, is he here? R.R. Gogoi. For forest,
Lordship, he is on legs.
will be appearing in this matter? You'll be appearing. We asked on the last occasion to tell us about the eco-sensitive zone. You got the documents of that?
Yes, yes, I filed my affidavit, my lord. Even map also I have filed, my lord. If you'll also permit me, my lord, I have, though I have annexed, is the big map, my lord, for the convenience of the people. We are outside the eco-sensitive. I have annexed in my
Actually,
affidavit also.
before, during pendency of the earlier writ petition, my lord, we have filed a writ petition before this honorable court, saying that in view of the report of the review committee to close down the particular fishery, saying that it is not viable for commercial fishing, and not direction not to issue any fresh tender for settlement of the fishery in question. That I have annexed the order, my lord, at page 17 of my infringement petition, my lord.
Page?
Relevant portion, my lord, page 19.
Document.
In this case, my lord, the notice was issued, and on my prayer to pass an interim order, the government advocate has stated that government has not yet taken any action for settlement of the fishery. In view of that, my lord, the honorable court had my overall agriculture petition, submit that an interim direction be issued restraining respondent authorities from initiating any fresh tender process for settling the Dibu fishery mohol under Tinsukia district. Learned Mr. Gogoi for the response 358 submits that as of now, nothing has been done. Taking into consideration the same, the court is at present is not inclined to pass any interim direction. However, liberty is granted to the petitioner by filing appropriate application if any action is thought to be taken by the state as well. And that case is pending. Like,
Yes, several.
In your petition, where is this 23-5 letter? Which page?
My lord, that is annexure, my lord, impugn order. That is at base 57, annexure 9. Last 2 pages.
57.
My lord. Of my writ petition. In the central notification.
Just
that is
a
also
moment,
there.
just a moment.
This is on the page. Have to. Yeah, I did that, it might be.
From where do I find this location of this Dibru Saikwa, this Dibru Part 1 fishery?
This is the outside, my lord. Our society is our outside, my lord. Lordship will see central notification. Page mark is there, my lord. Lordship will see the map which I have given. A2 map this one. The map central government has issued, my lord. A2. Page 191 of the affidavit, my lord. This is the central notification. For the convenience of the court, my lord, I have printed out separate. I have an next map. This is the map, my lord, which is national park. And our case is, my lord, we are beyond eco-sensitive zone, 1 kilometer. That too, my lord, 3 times. Committee has set into for re-verification, my lord. Then finally it has come by notification, my lord, that I'm coming.
Where is the notification?
Notification, lordship will see page 181 is the central notification. And Hindi is also there, my lord, for the convenience of the court, my lord.
No, this Dibru Part 1 fishery, where is the boundary?
Boundary, it is there in the notification, my lord.
Where is that?
In our case, my lord, next to 1, my lord.
Page?
Page. Page 37, Annexure 3. This is the fishery boundary, my lord. This has no relevancy with.
May I please, lordship. My lord, same measure, my lord, has been challenged by another petition by one Shri Arun Chandra Das. My lord, where my lord notice of motion has been issued by this honorable court without any interim order. And in fact, my lord, I have received a pedagogic comments from the DFO, my lord, as requested by the Deputy Commissioner, Fishery Branch. My lord, may I
Yes.
place this, my lord, order of the similar case where my lord notice of motion has been issued. And I have received the instruction where from my lord, your lordship, my lord, why my lord, that my lord restriction has been imposed.
No restriction, my lord. Government has initiated. Page 37, my lord, starting from coordinate.
Just one.
Arun Das. 3193.
In this, which will be east?
My lord, this is the only, my lord, bound this yellow, my lord.
No, it's okay, but which is east?
East. How about east? That's it. Just a minute, man.
This must be there a part of
Yes,
notification
yes.
also, huh?
It is
Okay.
there, my lord. Lordship kindly turn to page 191 or 195. This is the east, my lord, right hand side. Point number 1, my lord, 191. GPS point 1. Extreme right hand side is the east. East, west. East, west. South, north. Green, green na red. Na na. Itu আছে না? Green to. Our case is only, my lord, Dibru, Nadi, my lord, not other.
So Gogoi, you are there?
Lordship, one more thing I like to apprise, my lord.
Just a moment, I have something in mind, I'm reading that.
Lordship,
For that purpose, I'm reading it.
Lordship.
You have a better copy of page 34? 34, 35, do you have a better copy?
Notification. It is earlier bounded, first, third time, my lord. Entire map, my lord, of entire national park, including S2. Prior to issuance of final notification. All the picture will be clear, my lord, if your lordship turn to 1204 of my affidavit, my lord. 204 page.
Yes.
They are sought for clarification, may I read, my lord? Clarification regarding against Dibru Nadi fishery number part 1, your
Just,
letter.
just one.
Before redefined boundary, my lord, what are the activities have been done by the competent authority sitting in a committee, my lord? 204, annexion 19, serial number 1. May I read, my lord? As per-
Just a moment. 204, yes.
204, my lord. Submission of the clarification in respect of Dibru Part 1 fishery mall. These are the memo numbers, my lord, sought for clarification. Kindly refer to your letter. I have the honor to submit here with the re-verification report with the Google Earth map regarding the clarification of the status of Dibru Nadi as sought for from your end, as directed by the committee constituted for the resurvey of Dibru Nadi Part 1, submitted a fresh report after proper verification on 21/8/18. The findings of the committee are given below as follows. Number 1. As per the report of re-verification committee, redefined river starts from coordinate number so and so near Satapang Tea Estate and bridge, then goes towards to downstream site coordinate number so and so Tiburia Gao number 2, which is 1 kilometer ahead of Maguri Matukpang wetland, and eco-sensitive zone of the Soikia National Park. The river flows in the natural so-and-so immoral period and so-and-so boundary defaulted tea garden so-and-so, but does not pass through the tea garden areas. Total area of the proposed redefined Hebrew part 1 is so-and-so kilometer approximate. In view of the above, Revenue Department may take up the initiative in this regard. This is for your kind information and necessary action. The next page is the minutes, and 206 is the committee members. One SCS officer, one DFO, one SCS, ALRS, and district fishery officer. Double. User 7 is the signatory of the person who conducted the seminars. Initial and the final was.
Mr. Sharma. This, sorry, not Mr. Babia, this 2018 is the current map of the, of this,
Yes,
part 1.
because of which I have annexed, my lord, I have given the printed copy. And this is the final. This is national boundary, national park, NTR, which is eco-sensitive and which is the green one is the national park, the yellow park is eco-sensitive, and we are at 1 kilometer away from yellow mark. And we have no relevancy with the Matungpang or something, my lord, as stated in the impin order, my lord, for which I brought all the things in record, my lord. Please give an asset notification. Central notification of page 100 command.
Mr. Gogoi and Mr. Sharma. Now you see this, if Mr. Babia is correct, that the boundary is 204, page 204. Then, as per this gazette, boundary given at page 190, 189 onwards, boundary description of eco-sensitive zone around Dibru-Saikwa National Park, which is given at 189. And if actual coordinates are referred to at page 194, then this fishery must go on.
It has,
My lord, in the other case, my lord, there is some subsequent communication after the, my lord, communication dated 23, which is impugned in this, my lord, petition. I remember, my lord, that file is not with me. My lord, notice of motion has been issued. My lord, subsequent to this 23, my lord, letters, 23/5/2023, there are some letters which has been issued by the fishery department.
No, you see, letters are okay.
My lord, what my lord was the difficulties? My lord, to the, my lord, point of sale point, they have to come, my lord, through the national park.
Go to judgment.
They have to, the fisherman has to pass through the national park. That may be the difficulties, although, my lord, that may be, my lord, outside the boundary, but they have to cross the all the
Question of
fishermen.
crossing does not arise, my lord. He is connecting
my
with
lord,
other fishery, my lord,
And
other read petition, my lord.
Lordship,
Where is
if-
the question now? We are totally outside.
No, you can effectively restrain them if they are not to traverse on the
That is
eco-sensitive
why, my
zone.
lord, only thing, my lord, without permission, without
They need a
valid,
permission from a chief wildlife warden if they want to go through the eco-sensitive zone, your lordship.
No, we are.
Yes, they need a permission, lordship. It's a
No,
notified.
no. You see, it is for the forest department to stop use of eco-sensitive zone for passage.
Yes, your lordship. But if there are certain reasons, they are, as per Wildlife Protection Act, your lordship, Rule 27. Permission is accorded neither, your lordship.
Hmm?
Permission is needed from chief wildlife warden. If,
No, question of permission will come when he traverses from that
yes,
point.
your lordship,
Correct.
yes.
We do not go there.
So if he does not, if he has no permission, you can stop him.
Yes, your lordship, we can.
Coercive steps can be taken.
Yes,
You can
sir.
arrest him.
Yes, your lordship.
Correct. But why this fishery has to be stopped? That is what my question is. Mrs. Barwa, you can also address us.
From the very beginning, from 2017.
Please come over here. I can't hear you.
From 2017, my lord, the committee appointed by the government, my lord, for review of this fisheries, my lord, falling within the jurisdiction of NSPN. Regarding the Dibru Part 1 fishery, what was the objection? The committee, after verification of the ground and map, it has been decided the stream passes through Pangira and then passes through Torani Reserve Forest Dunduma. It shall be a small stream. Actually, river is a small stream. Small stream part, which is also falls in the reserve forest, is not viable for commercial fishing. Further, the small stream.
You are reading from
also-
where? You are reading from where?
Page 23.
23.
Of its petition.
This is the second notice, first notice, before my. Before notification.
Yes.
The committee, after verification of ground and the map, etc., it has been decided that the stream passes through the Penray and then passes through Tarani River Forest. Under Dumduma Forest Division, it is a small stream, part of which also falls in the reserve forest is not viable for commercial fishing. Further, the small stream also ultimately passes through the Maguri Matabu Bill wetland, which also falls within the eco-sensitive zone of DSNP, where commercial fishing cannot be allowed. Further, at present, there is no linkage with the Nala started from Panigra with the boundary of Dibru Nodi Part 2, as mentioned in the original definition of the fishery mahal in western side. Dibru Part 2 also falls within the jurisdiction of buffer zone of DSNP and DSVR and eco-sensitive zone of Dibru Soikha and Masal Park. Hence, the committee opined that Dibru Part 1 fishery mahal is not viable for commercial fishing, and hence revenue authority may be requested to close the mahal and not to put the sale in future. Thereafter, my lord, the matter came up before the Honorable Court on several times. In one writ petition, the Honorable Court, Honorable Mr. Justice Rishikesh Roy was pleased to pass an interim order not to allow any commercial fishing in this particular fishery. After that, also the government had issued a notification prohibiting the commercial fishing in the state fishery.
Where is that notification?
That is not, he is not mentioned in the writ petition, my lord. But in my earlier repetition, I have stated all these things.
You have a copy of that notification?
My lord,
Do you have a copy of that notification?
এখনো কথা।
Section 3 of my repetition.
Huh?
That okay, sir?
It will not be. Lordship are making query of page 23.
23. No, Mrs. Barwa says that there's a notification of the state government prohibiting.
Actually, in
It
the
is the
next
first,
year's
there is a
state
three
budget
meeting,
is
madam, I'll
coming.
clarify. Learned senior council has relayed the first meeting, then second meeting, ultimately third meeting. Kindly see the date, madam, page 25.
It is there in the next item, my lord.
Page 25 be seen, my lord, it is way back in 17. Before sending proposal to the central government. Page 25. 29/7/17. In respect of earlier boundary.
This page 22 is what date?
Page
Meeting-
22 is the type copy, my lord.
Okay, same thing.
Page 25 is the vernacular.
29/7/27.
29/7/27 in respect of 10 feature.
Okay,
Then prior sending to the proposal. To the government, concerned government. Then my lord affidavit, lordship, I have shown page, my lord, lordship has already seen. There is a second minutes,
where is that?
second minute, lordship will see at communication at page 202 of my affidavit,
202.
202. They made several queries. my lord. Last part, lordship will see. Major area of Dibru Nadi Part 1 under the tea garden area, leaf SF area, construction revenue authority using national side along with the garden areas, so and so. Then again, queries has been made by page 203 in respect of tea garden. 203, they made specific queries by the additional secretary, Government of Assam, Fishery Department. In the case within the tea garden area lease partition, so and so lease out land, tea garden may be furnished along with the trace map showing the lease area of so and so tea garden. That then 204 is the reply. Followed by field verification, page 205. This is the third and final. Thereafter, my lord, notification has been given. Boundary redefined. Earlier was a big fishery, now it has become small fishery. Which is 1 kilometer away, Maguri Matukpang wetland and eco-sensitive zone. But that has been carved out. We no need to visit there, go there. Our is totally different. Lordship, kindly note down the dates. 23rd August 2018. Verification has been reconducted again on 14/6/18 at page 205. Central notification. And to be confirmed, my lord, central notification, page 118, serial number 181, central has notified. After that, boundary has been defined. Eco-sensitive zone also defined. Next page. 822. Operative part, my lord, lordship will see at page 182. Now, therefore, in the exercise of power conferred under section so and so, subsection 3 of so and so Environment Protection Act 1986, further in a notification thereof to Environment Act so and so, sub rule 3 of rule 5 of the Environment Protection Rule 1980, central government hereby notifies the area to the extent from 0 to 0.8.7 kilometer around the boundary of Dibru-Soikia National Park in Dibrugarh and Tinshukia district. This is the green and yellow. Green to yellow. From green to yellow, it has to be 0 to 8.7. And eco-sensitive zone is the yellow. Green to yellow has to be in some places, it is 500 meters, some places, but 0 to 0.8 kilometers. So I have no relevancy, my lord. With the eco-sensitive zone, Matungpang also, we no need to go, and DFO has no authority to make such a communication which is impugned in nature. And in violation of central government notification, the mere DFO cannot do that. They have published map also.
What are the rate petitions pending in this Dibru Part 1 fishery?
No rate.
No, there are
Order
pending.
disposed of.
No, there are pending.
No, my lord, I am the secretary of the Dibru Part 1 Cooperative Society. There was an order, my lord, for the honorable court, my lord, lordship will see at page Annexure 7 at page 48. That is disposed of, directing to go for settlement.
Page?
Page, my lord, 48, my lord, read petition number 48 to 55, my lord. Operative part, lordship will see in read petitions.
No, there are pending.
No, my lord, my matter is disposed of.
No, I am not talking of your matter.
My lord,
But
lordship will
Dibru
see
Part
the-
1 fishery is a part of.
Maybe, my lord, other matter, my lord. Dibru Part 1 is I am the only one. Maybe other fisheries, my lord. In respect of my lord, in respect of other fisheries. We have prayed, my lordship will see the operative part. Page 53. The petitioner counsel submits that the private respondent has been allowed to operate the said fishery on daily basis on the ground of regular settlement has not been done. Respondent authority, he submits that the same being violation of Rule 12, Assam, the state should be directed to issue NIT regular settlement of the fishery. Mr. Sharma and Mr. Chaudhary, landed counsel for the respondent, submitted that do not have any objection to the prayer made by the petitioner to enable the said respondent to float the tender for regular settlement of the fishery. In view of the parties, the state respondents are directed to make regular settlement of within a month from today and complete the entire process of settlement by issuing NIT and selecting the successful bidder within the further period of 1 month. It is made clear the present arrangement of running fishery shall continue till 15 July. That is the temporary. Who has been enjoying money? Some third party. Then an impugned letter, my lord, from where he got, my lord, all these things, but debiting the Supreme Court decision and central government notification, state government also published notification. And in redefined boundary, my lord, what makes him to again redefine? Already we are outside map published. And concerned department, central government, state government use their manpower. So in view of that, my lord, the order issued by impugn has to be stayed and has to go off. This will contradict the provision, settled provision of rule. But as on date, my lord, some third party is enjoying the daily basis, like temporary basis.
Where is this order? You said 23/5/23. Where is that?
23/5. 23/5/23.
The impugn order.
Impugn order, lordship will see at page of my read petition, page 57, annexion 9. After receiving of the order of the High Court, my lord, Honorable High Court directed to go for fresh tenderment, and a copy was duly served upon him because being a party, and he issued this impugn order. And if your lordship permit me, my lord, I can show the copy was duly served upon him, my lord. Huh? Oh, it is there, my lord. With reference, I wish to inform the Honorable High Court passed a
Yes.
common judgment.
No, it's okay. Yes, no.
My
What
lord,
do you have to
actually,
say?
my case number 2374 of 2022, my lord, regarding this particular fishery, where I have said that there won't be any settlement of this fishery and fishery should
have
be
that,
closed down.
You have a copy of the writ petition?
Yes, yes. Yes, yes. Yes,
We have annexed the order, my lord.
No, copy of the writ petition.
In the infringement, my lord, case 2019.
Hmm?
Case 19 of my infringement.
Page 19 of.
Of my impleadment petition, my lord.
In person, yeah, my lord, I got the copy of the other writ petition, my lord. Is the
Ask for the
individual
writ petition.
person made, my lord, in person
Ask
to
for the
High Court
writ
order.
petition.
He took only. And that too individual, my lord. I'm cooperative society. And they are Matungpang, my lord, inside the equal sensitivity.
That apart, my lord, I am told that another fishery, my lord, Rangagora fishery, has filed a petition regarding the same fishery, my lord. 2213 of 22.
That is, my lord, in nutshell, what I understood, my lord.
Please don't respond to everything.
No, my lord, I'll just make it
It's
clear.
okay. Let me read. I'm reading
No,
something. Please don't respond. What has happened to the proceedings of WPC 4902 of 17?
Disposed of in review also.
Hmm?
I have an next mallet in my affidavits.
Where is that?
That your lordship will see. Page 76, my lord. Is the order,
76.
my lord, page 76 of my affidavit. Then lordship will see. Review to court. 76 is the order and 79 is the review.
No, then this fishing can't be stopped, Mrs. Barwa.
My lord,
This fishing can't be stopped in that area. It has to go on.
if there is no viability for a
No,
commercial.
question of
fishing, my lord,
viability,
it-
question of viability is something which the government will decide whether the fishing
that
is viable or
they-
not.
They have appointed a committee, they review the,
No,
all
it's
matters.
the deputy commissioner who's poking his nose.
not deputy.
You see,
commissioner,
government
my
of-
lord, pursuant to the direction of.
No,
the
you see, Mrs.
commissioner,
Barwa,
my lord.
you come seriously. You see, number one, the government of India has notified the eco-sensitive zone.
Yes,
It has given coordinates.
yes.
And it has also issued it has tagged the geo map along with the coordinates in the notification, gazette notification.
Hmm.
Correct.
Yes.
Now, the deputy commissioner nowhere says that any part of that boundary is being touched by by this fishery. What they are saying is that it is not viable, it is passing through the land of a tea garden. And then-
eco-sensitive zone, my lord.
It can't be eco-sensitive zone if it's not within the boundary. That is why you see, last time when it came, I asked only one question. That where is the this coordinates of this fishery? Now these coordinates are here, it is available along with this trace map. If it does not touch, others have no business to interfere.
My lord, what the.
They
do you
find it from
call the
anywhere.
Wildlife related, my lord.
Does it change the coordinates? Does the wildlife say I don't?
Even changing the.
No, does the
coordinates,
wildlife,
my lord.
does the wildlife or any other authority, Assam Forest, take wildlife, take air pollution, take whatever authority you want? Has anybody said that the government of India is wrong in notifying the eco-sensitive zone?
If you logically turn to page 57 of this petition, my lord,
Yes.
this is the report call for.
No, because you see, daily fishing which has been allowed, nobody is challenging that. Very conveniently, daily fishing is permitted. Even you don't object to
No,
it.
that is also challenge, my lord.
Your-
The repetition 520 and 729.
We are challenged, my
On that, my lord, this honorable court was pleased to pass an order.
No, the High Court says that daily fishing, stop it, give a regular settlement.
That is the difficulty, my lord, regular settlement, whether regular settlement is viable, my lord.
No,
that
we
is
have
the issue,
expressed-
my lord.
You see, we have expressed our wisdom once, saying that no daily fishing, it should be a permanent fishing.
It
That
is-
wisdom we have already
it is
expressed.
held on fault on the
No,
part
that
of the
order
government.
has not been challenged.
It is challenged, my lord. It is, the daily fishing is challenged in the
No.
petition number 520.
Daily
and
fishing, the court has given its opinion. This court has given its opinion that no daily fishing. It's settled,
Yes,
regular settlement.
but regular.
That order has attained finality. And now when regular settlement has come, you are again objecting to it.
In that read petition, my lord, the commissioner and secretary of the government of Assam. Fisheries
I have seen
Department
you
has
you show me the,
filed an affidavit, my lord, stating all these things. Several times, my lord, reports were called for from the DFO Wildlife Division of Tinsukia, my lord, regarding viability and exact location of the fishery vis-a-vis the eco-sensitive zone. And
Then
all
are
the
you,
time, my lord,
no, are you proposing to say that the boundary of the fishery which has been given was without application of mine?
before fixing the boundary, my lord, government has called for a report from the.
Mrs. Barwa,
Yes, my lord.
you see, let me tell you, by the time you were all
My lord,
arguing,
Let me file an affidavit.
no, you see, let me show something to you.
Yes,
When I've done that exercise, I am showing it to you. Now this gazette notification. Please come to this writ petition. If you don't have a copy, you take it from Mr. Barbia. Come to page 169 onwards. 169 onwards, these coordinates are given. Correct. Then-
I do not find.
You give him a copy. Give her a copy.
Yes, I can give my lord copy, lordship. My copy is making.
No, just for some time, give her a copy. In this notification, if you will come to page 169 onwards, you will find all coordinates given. This is a part of gazette notification of Dibru Saikwa National Park,
Page number 2.
Oh, yes.
correct? Then it continues to 173 onwards.
Okay, yeah, 2020.
You come to page 169 onwards, every coordinate is given. 95 degree 36 36 feet 15.504 inches. Correct. This,
I didn't find when he has given his copy to
ah,
me.
it's okay. You take this copy, everywhere these coordinates are given. Now, if you come to the actual notification, you come to turn over to page 189.
Yes.
Yes. 189, last two lines you see, boundary description of eco-sensitive zone around Dibru Saikwa National Park in the state of Assam. Correct. Now, next page, if you turn, you will get all these coordinates which are there. Earlier, I showed you. Page 179 onwards. All those coordinates are there. Correct. Now, in English also, after this, you'll find the coordinates are there at 194 onwards. The geo coordinates are available. Come to 196. Earlier was the Hindi table. Now it is in English. 196. Again, you will find latitude, longitude, all the coordinates of Dibru Saikwa National Park along with geo coordinates. Correct.
Yes.
Now, once this is over, then you come to this page 19. Sorry, 204. And Mrs. Barwa, I can tell you, these are 4 pages of coordinates given, 4 or 5 pages. Correct. You can take it from me that I have read it. And I am showing you page 204.
Yes.
Coordinates are given. Not even one coordinate is touching on the gazette notification of the Government of India. You show me one. There are 5 or 6 pages of coordinates.
It says, well, it is about 1 kilometer ahead of Magori Matapur wetland. Because sensitive.
No, these coordinates must match.
Yes.
You see, let us assume that we two are neighbors. Correct. You and me, we are neighbors. My house is situated 1 feet after your boundary. Correct. So should I be prevented from entering into my house?
My lord, entire difficulty arises, my lord, with this formation of this new boundary, my lord, and all that, because.
No, you must take a stand. Mrs. Barwa, this is why you will have to take a stand. Either the Government of India is wrong, or this, this fishery is wrong, Deputy Commissioner is wrong. The Deputy Commissioner gives a coordinate and then says, redefine it again.
Redefined because of the objection of the forest department.
Well, everybody will object to
Because they-
everything.
They are saying that it is not viable. because
Everybody
of
will
the
object to everything.
To the eco-sensitive zone, and there is possibility of pilferage.
No,
They
everybody,
may, the fishermen may come.
in
because
what thing you have seen that there is no objection?
It is there. my lord,
What
because
thing
in-
happening in the country is having no objection?
In the earlier repetition that has been disclosed, the 115.5, my lord.
No, I'm not,
There also
I'm
the
asking a
commission has
specific,
written detailed
I
affidavit.
am, your affidavit may be detailed, just show me that
It is complete affidavit.
whoever has filed it, just show me that one coordinate touches on the other.
No, it is an admitted fact that there is a gap of 1 kilometer from the eco-sensitive.
Then why you can prevent that? We'll record it and we'll permit
Because,
that.
my lord, there's, that it is a narrow strip of stream,
No,
my lord.
it is just like two,
Viable for fishing,
it is just like two political parties
not
where
political
one does
party.
anything, the other will object.
It's not political party. Let it come on another day. I will go through all those things or let my.
No, let
legal
us
serve a
proceed.
copy on me, my lord.
Whatever, whatever settlement is going on will be subject to further orders of the court. Let that proceed. If it is not touching the boundary, you can't just presume. Presumption
But,
can't be there.
But question of viability will always be there. Maybe he is in the.
Am I required to look
outside
into the
my
viability?
eco-sensitive zone.
Is it within my domain as a writ court under 226 to look into the viability
And
when
that
there is a
what
tendering
the
authority?
Appointed a committee to revisit all these things, my
They
lord,
can't do
regarding
anything.
proximity to the eco-sensitive.
They can't do
zone.
anything. They can't change the coordinates. Once they can't touch and coordinate. Mrs. Burrow, just think, your boundary is not changed. You
The
are living in
stream
your
is
own,
Small, my lord.
no, you are living in your own house, with your own boundary. X is living in another boundary 1 kilometer away. And can you claim that, no, I have a threat that my house will be encroached and therefore stay?
If there is no water in the stream, my lord, how they will have gone.
Oh, don't worry. Then you are, then I'll have to show you something. Don't worry, if that is something you want to know, I'll show you. Boundary of the fishery is 95 square kilometers. Correct?
But it goes through the.
No.
forest-
Please
forest
understand.
limit. Yes,
This is 95 square kilometers of,
length.
no, not length, boundary. Boundary may be what I don't know. Correct. Have you heard of any water body in Assam having 95 kilometers of boundary except river Brahmaputra?
Well, that is why.
No, have
further
you heard?
study is necessary because, my lord.
Have you heard? No, you will never
because,
hear
my
it.
lord, the.
No, don't. No, I will show you something. Incidentally, under the Assam Land and Revenue Regulation, fishery includes land and water bodies. You are aware of it? No. I forgot these things that long back. Fishery.
Hello, I would like to draw your attention to page 57, my lord.
No,
Once
but you
again.
must understand
Once
what is
again, my lord.
what is fishery. Rights in fishery 18. You see this provision is 16 in Assam Land and Revenue Regulation. Fishery incidentally does not restrict to water.
Then the two.
16. Fishery rights. So therefore, until the boundary touches, it touches the eco-sensitive zone. All these, what you call objections are commercial in nature.
Their main concern, my lord, regarding the pilferage of the fishing in the eco-sensitive zone, my lord, because they are repeatedly saying in government has called for various reports from time to time in different petitions, my lord, after
That will happen
orders
because you
passed in the
see,
requisition.
that will happen because no court will, in the motion time, spend 2 hours to understand what these coordinates are. And once I have done it,
I may again, my lord, draw your attention.
no, you
Case-
file your
case
affidavit,
57,
67,
57. of
57.
the-
Yes.
In this regard, I was bring to your kind notice that a committee was constituted to define, redefine the frontier. And file order dated 18/21, accordingly, bill verification was conducted on 29/7/2017. The committee decided that the stream of area in question is not viable for commercial fishing. Moreover, this stream ultimately passes from
Mrs. Barua.
Bill.
Mrs. Barua, High Court has given a decision. Is the deputy commissioner our appellate authority of this court?
My lord, actually, that case, my lord, the consent order was passed, my lord, without hearing the parties.
It's okay. The,
Government affidavit detailed the filed by the commissioner, my lord.
in a fishery case, is the case heard without hearing a deputy commissioner?
Because the fishery was without, remained fast for a long time because of litigations pending in the National Green Tribunal as well as before this order
No,
where interim
First
orders
of all,
were passed.
no.
That
Please,
is why, my lord,
please finish one section. You are arguing on this page 57.
yes, please.
There is a judgment of this court 15/5/23 passed in WPC 520. Is the deputy commissioner party there?
Where?
You are showing me page 57. I am reading it. My question to you is the deputy commissioner party in this WPC 520 of 2022?
Yes,
Right.
yes.
So this deputy commissioner accepts the order of the court and then acts as an appellate authority that fishing is not viable. He did not have the courage to come to court and ask for modification of the
For
order.
modification, that's why
Then-
last time, my lord, I had.
It can't be permitted. He is not our appellate authority. I won't have regard to the deputy commissioner overreaching the order of the court.
Because
Listen.
even the government affidavit was not placed before the honorable court, my lord. That is why there is mention, my lord, regarding the
I
affidavit.
am
What
not
is the
hearing-
stand of the government? Only one line.
Correctness of the order in 520, I am not hearing here. So therefore, you cannot address me on that. Correctness of the order passed in WPC 520. I am not hearing that.
It is a one line order, my lord.
Whatever be, it may be half line.
In
It may
view
be
of the
half line.
consent of the parties, state respondents are directed. to
There was once a
make regular
deliberation.
settlement.
There was once a
That is the
deliberation
order.
in this court, in a vacation court, where the senior lawyer who is no longer now alive, he gave a suggestion that in all cases you can say that writ issued stay and the matter is over. And you know what the honorable judge retaliated? He said, no, why 3 words? I can dispose it of by 1 word, dismissed. So it's not a question of whether it is a half line order or 1 line order or 10 line order. The deputy commissioner is a party to it. He accepts the order and then goes back to his office and says that no, we'll redefine the boundary.
Yes.
High Court says you go ahead with the tender.
Actually,
He
that
says,
is
no,
not-
I will now redefine it.
That's why they appointed the committee to go through the
In fish, everything is
boundary
fishy.
and the five
In
regarding.
fish, everything is
the
fishy. No,
fishery, my lord.
I am not convinced. But Mr. J.I. Borgnia, Leonard, counsel for the petitioner, Mr. D. Sharma Leonard, additional senior government advocate appearing for respondent number 1, 2, 3, 4, 6, and 8. And Mr. R.R. Gogoi Leonard, standing counsel for the Forest Department, appearing for respondent number
4, 5, and 7.
4, 5,
And 7.
and 7. As with this, just in our case, Mrs. U. Barwa, Leonard, senior counsel assisted by Mr. S. Count, Leonard counsel appearing for party applying for impediment. Next paragraph. By a notification dated 8/10/2018, issued by the Secretary to the Government of Assam, Revenue and Disaster Management Department, the boundary of Dibru Part 1, Fishery Mahal, was redefined. So it is projected that the said boundary is still in force. Full stop. The Divisional Forest Officer Tinsukia Wildlife Division, Borguri, Tinsukia, by the impugn letter dated 23/5/2023 to the Deputy Commissioner Tinsukia, has opined that the on-ground status of the said fishery is that it was not viable for commercial fishing. Full stop. Accordingly, the Deputy Commissioner Tinsukia was requested to kindly look into the matter prior to floating of the NIT as directed by this court, and to do re-verification on the ground regarding the viability and veracity of the present day status of this Mahal area, taking into view of the proximity of the eco-sensitive zone of Dibru-Saikhowa National Park, where there is every possibility of breach of peace if any attempt to trespass into the eco-sensitive zone for fishing is made on plea of the Dibru Nadi Part 1 Fishery Mahal. Full stop. Accordingly, questioning the said impugn letter dated 23/5/2023, issued by the Divisional Forest Officer, Tinsukia Wildlife Division, Tinsukia, within bracket respondent number 7, is assailed in this writ petition under Article 226 of the Constitution of India. Next paragraph. Issue notice of motion returnable in 4 weeks. Requisite extra copies of the writ petition be served on the Learned State and Departmental Council in course of the day. Within 2 days. So the petitioner shall also furnish a copy of the writ petition as well as additional affidavit filed. Additional affidavit to comment. Number 2, additional affidavit filed by the petitioner to Mr. S. Count Learned Counsel appearing for the private respondent. Next paragraph. Heard all sides on the prayer for interim relief. Full stop. While the Learned Additional Senior Government Advocate, Mr. R. Gogoi, Learned Standing Counsel for the Forest Department, and Mrs. U. Barwa, Learned Senior Counsel for the private respondent, have vehemently opposed any interference with the impugn letter dated 23/5/2023, but on a perusal of the but on a comparison of the eco-sensitive zone of the eco-sensitive zone around Dibru Saikhowa, DIBRU-Saikhowa, SAIKHOWA, national park in the state of Assam. Which is which was published, the notification dated 28/1/2020 on the boundary of so and so, which was published in the Gazette of India Extraordinary for Part 2, Section 3 within bracket Roman 2. Dated 31/2020, comma. It contains geo coordinates and the description of the boundary covering the south, west, north, and east of the said national park. Full stop. Next paragraph, also peruse the minutes of re-verification report of the committee constituted for resurvey of Dibru Nadi Part 1 as per government letter number Fish capital FISH dash 19/4/2017 fishery dash part within bracket 1/199 ECF number. This will be 205 and put a flag. The redefined river coordinates have been given. Full stop. As per the said minutes, comma, the boundary of the redefined river is away 1 kilometer away of Maguri, MAGURI, Motapung, MOTAPUNG, wetland and eco-sensitive zone of Dibru Saigoha National Park. Full stop. The total area proposed of the redefined Dibru Part 1 fishery mahal is about 25.93 kilometer within bracket approximately length. Full stop. The learned state departmental council as well as learned senior council for the newly imputed respondent have not been able to show that any of the coordinates for the Dibru Nadi, Dibru Part 1 fishery mahal touches upon the boundary of the eco-sensitive zone. Full stop. Next part. This code by order dated 15/5/2023 have disposed of WPC 728 of 2022 and other connected cases. By directing the state respondents to make regular settlement of the fishery within 1 month and to complete the entire settlement process by issuing an NIT and selecting the successful tenderer within a further period of 1 month. And it was made clear that the current arrangement of running the fishery shall continue only till 15/7/2023. Full stop. Next para. It is also noted that while the deputy commissioner was arrayed as respondent number 6 in the said writ petition, the divisional forest officer, Tinsukia Wildlife Division, Tinsukia, was also arrayed as respondent number 9 in the said writ petition. Full stop. None of the respondents therein had moved this court for modification of the order or the order of this court dated 15/5/2023 has not been questioned in appeal. So therefore, for all intents and purposes, the direction contained in order dated 15/5/2023 passed in WPC 728 of 2022 and other connected cases have attained finality. Full stop. Next paragraph. Therefore, the court is unable to accept the request made by the divisional forest officer, Tinsukia Wildlife Division, Tinsukia. Do you have any power, authority, or jurisdiction to form an opinion that the commercial fishing was not viable? Full stop. If he had that opinion, he could have moved this court for reconsideration of the order dated 15/5/2023. It was not done. Full stop. Therefore, the court is unable to hold that the inquiry is required by the impugn letter dated 23/5/2023 is permissible, as it would amount to overreach the orders of the court. So accordingly, the court has no hesitation to stay the operation of the letter number, so page 57, dated 23, issued by the Divisional Forest Officer, Tinsukia Wildlife Division. Next paragraph. As the court has no doubt that eco-sensitive zone must be respected and protected at all costs. Comment is provided that in the event any of the respondents are able to demonstrate that any boundary of the eco-sensitive zone of Dibrú-Saikhowa National Park is overlapped with the boundary of the Dibrú Part 1 fishery, such respondent would have tried to apply for modification of the order. This list after so and so. There's an IA for impeding by this is IA number 1819. This is allowed. We are allowing this in today. This you were with S count objected by GI Bodmia. Yes. So item 68.
68.
Lordship, and the last part, our interest in protected.
68, I'm appearing as
If the petitioner somehow comes in eco-sensitive zone, we may be liable to take action against the petitioner, Lordship. If somehow they crosses the.
Yes, yes. This order would not
What was it?
would not prevent the divisional forest officer, Tinsukia Wildlife Division, to take appropriate measures against any person who is found to be breaching the eco-sensitive zone without any authority of law.
Very well, Lordship.
Okay.
68.
Yes, 68.
My lord, there, my lord, I have been added as respond number 8, my, or 11, my lord, so I want to make my.
My lord, in this case, my lord,
Just now.
no, I am withdrawing this.
Okay.
My lord,
Okay.
I
You may, you may,
permitted to withdraw this petition.
you may come in
My lord.
review jurisdiction.
My lord,
You may come in review jurisdiction.
yes, my lord.
Okay. Heard. Mrs. U. Barwa, Learned Senior Counsel, assisted by Mr. S. Counsel and Counsel for the petitioners, as well as Mr. G. I. Bormia, Learned
Respond number 11.
Counsel for Respond number 11. Government will be appearing. This is M. Burman, Government Advocate for the respondent number
It was at the person, I said, I would.
1, 6,
1, 2, 4, 6,
no, not 2,
7.
1, 6. This is G. Hazarika, Standing Counsel for Revenue Department, appearing for respondent number 2.
Read petition saying.
Mr.
67.
R. Gogel, Learned Standing Counsel for Wildlife, appearing for respondent number 5, 8, and 9. Next one.
68 to.
Upon instructions from the Learned Senior Counsel for the petitioner, seeks to withdraw this petition and to approach this court. In review jurisdiction. Or and of the or any other appropriate manner. Full stop. Prayer is allowed. The petition stands dismissed from withdrawal with liberty as prayed for.
My lord, liberty may not be given, my lord,
No, no, I
because
have to
I'm
give the
challenging
liberty.
their locus, my lord.
You can't challenge the locus unless the review is filed. Correct.
Yes.
You want me to adjudicate before you file, before she files the petition? Then we are at,
Still, Lordship.
we are at the end of the day.
Lordship.
I can't hear that.
Lordship. My lord, may I take that copy, my lord, which I have given, my lord?
Oh, yes.
No, my lord, not that one. That, my lord, perusal of the.
It's okay. Next time you give it. We.
Lordship. It will have, Dada, I do it. Map file to throw you for file.
Yes,
Map is-
item
is kept-
69.
Kept in the file.
So Manik is not there.
I'm sending in from Mr. Ashwani. We have to leave the courtroom due to some urgent.
Okay, but it will amount to a contradictory order. In this writ petition, he has produced some document which will be relevant. So both matters will be to head together. What did you suggest yesterday? I forgot.
My lord, what I said that in the other case, my lord, we could not apprise your lordship, my lord, that so far as the first petitioner is concerned, election was already held. So therefore, your lordship's observation was that since, my lord, it had spent its force, my lord, the board, so election can be held. Now, by this time, election is already held. My lord, the petitioner is challenging, my lord, the legality of the election.
It can be done in this way, my lord, that order will remain, the earlier order. Now your lordship can relegate, my lord, the petitioners to the register. Register will decide, and in case, my lord, register finds, my lord, there was illegality, he will, my lord, again direct, my lord, election in terms of the earlier order. And if the register finds there is no illegality, my lord, then the order of the register will merge with the earlier order, my lord. That is, my lord, I think that is the way.
Uh, uh, Your name?
Mr. M Rana.
M. Rana, yes,
M.
I
Rana.
forgot. Mr. M. Rana, then counsel for the petitioner. And Mr. S.K. Talukdar
Taruk,
Leonard,
right.
standing counsel for the Corporation Department, appearing for respondent numbers
1, 2, 3, and 5, my lord.
1, 2, 3, and 5.
4, my lord.
So Ms. M. Burman, government advocate, appearing for respondent number 4.
Other respondents, my lord, notice may not be required because the registrar, my lord, since they are stakeholders, the registrar will issue notice to them, my lord.
In view of the nature of order proposed to be passed, comma, the issuance of notice on the private respondent numbers 6 to 22 are dispensed with. Next, but it may be mentioned that similar matter was disposed of by this court by order dated 13/6/2023, passed in WPC 1323 of 2022. And as there is every possibility that two inconsistent orders may come on board, this matter was listed along with the disposal of records of WPC 1323 of 2022, so that the counsel for the petitioner in the said WPC 1323 of 2022 is also present. First of Mr.
D. Bora, standing in for Mr. S.
D. Bora.
D.
G.
Bora on behalf of.
D. Bora, my lord.
D. Bora, the counsel is in attendance on behalf of Mr. S. Banik, counsel for the petitioner.
Petitioner in 1323, my lord.
The petitioner in WPC 1323 of 2023. Next paragraph. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the election of Dakhin Boguribari, DHAKHIN Boguribari, Synopsis Limited.
Held on 5/6/23, my lord.
Held on 5/6/2023. So it is projected that it is alleged that the said elections was MIRAD with various anomalies for which objections were raised, but the returning officer did not allow the objection and continued with the election. And accordingly, the petitioners claimed to have filed written complaint before the Deputy Commissioner and Assistant Registrar of Cooperative Societies, Bapeta. Next paragraph. The court finds that as there is an election dispute, the appropriate authority to adjudicate election disputes is the Registrar of Cooperative Societies as per Rule 27 of the Assam Cooperative Society Rules, Election Rules 2019. And therefore, it would be appropriate to relegate the petitioner to approach the appellate authority.
Election authority.
Election authority Next para. However, it may be mentioned that in connection with WPC 1323 of 2022, the this could be ordered till 13/6/2023. Permitted the it was be held by one-man committee.
Yes, my lord. In fact, Lordship may quote para 4. In that para 4, your Lordship had indicated that so far as petitioner one, including another, my lord, the election will be held and the directors may be allowed to participate.
4 and 5.
Yes, my lord.
4 and 5.
5 may not be relevant because this is in respect of other petitioners.
Okay,
Here,
4.
yes, only
okay.
4, my lord,
Four.
that board is concerned, my lord. 4, my lord.
Full stop.
To reconcile that part, your Lordship will say, my lord.
Next para. It appears that the elections which were already held on 15/5/2023 was not brought to the notice of the court.
Yes, 5/6/23, my lord.
Oh, sorry, 5/6/2023 was not brought to the notice of the court.
Lordship will say inadvertently, my lord.
Please, I'm not saying, I'm not blaming anyone.
Yes, yes.
It's not busy for the court. Or perhaps inadvertently.
Correct.
So therefore, the only way to reconcile the previous order with the present order, present case is to direct the to delegate the petitioner in this writ petition to approach the election authority in an appropriate manner. And the said authority shall hear the concerned parties on the objection raised against the election held on 5/6/2020 and pass appropriate orders. Next para. In the event the elections are upheld, comma, no, I don't need to say what would happen. Should delegate to the authority and the petitioners in this.
In fact, thereafter, my lord, the order of the register will merge, my lord, with your Lordship's order. At least Lordship should say that, my lord, because there will be inconsistency in that regard.
No, his order cannot be permitted to merge with the High Court order. So what we'll say is that in this proceedings,
My lord.
the petitioner in the other petition will participate.
Yes, correct.
Accordingly, it is to avoid inconsistency in the orders, comma, it would be appropriate to direct the petitioners in WBC.
No, my lord, in fact, that board is already dissolved. That board is no more.
No, if they want to object to that,
Yes.
because he is seeking an election. In the earlier writ petition, there is a direction for election.
Now, these are what I'm trying to say. Earlier, my lord, board came. Now, my lord, some shareholders have come saying that the present election is bad.
Correct.
So present shareholders, earlier board, my lord, different persons. They may
Correct.
not be the same persons, my lord. So what I'm trying to say, there may be some inconsistency in the order because your Lordship has already directed for holding of the election. Since election has been held, now if the my lord, register finds that election is required to be held, then my lord, he will direct, my lord, election in terms of your Lordship's earlier order. And if he finds, my lord, no illegality, then his order will match with your Lordship's order. Matter will end there, my lord. What I understand, subject to correction, my lord. Otherwise,
No.
there is already an order of your lordships, my lord, for holding election.
This is all. This is all. No, that's why we'll clarify that order also.
Yes, yes, lordship will clarify that, my lord.
Uh,
Otherwise, confusion will be there, my lord, because election has already been held.
Just next paragraph accordingly, if the registrar of cooperative societies holds that the election was proper,
My lord.
comma, then the order passed, order dated
1323. There will be no requirement, my lord, of holding election.
uh, uh, there will be no requirement of this, of the fresh elections to be held
In
pursuant
terms
to
of
order
para
dated 13/6/2023 passed in WBC 1323 of 2022.
Yes, in terms of para 4, my lord.
Full stop. Nonetheless, comma, if the registrar of cooperative society finds that the elections were not correct, appropriately held,
Yeah.
comma, in that event, the competent authorities in the under the registrar of cooperative societies would be would proceed to hold elections
Yes.
as directed by the hearing before referred,
Yes.
order dated 13/6/2023 passed in WBC 1323 of
Yes, correct.
2023.
In that case, the order will apply.
Ah.
Yes.
Next para. The just a moment. Next para. Let a copy of this order be retained in the record of WBC 1323 of 2022. Next para, under the next para, under extraordinary circumstances. Hey, now you pass another order in WBC 1323 of 2022. You Mr. D. Bara for the petition and Mr. S.K. Tarugdar for the cooperative society. Under exceptional circumstances, comma, from the it appears from the proceedings of WPC 3609 of 2023 that prior to disposal of this writ petition by order dated 13/6/2023, comma, an election were already held on 5/6/2023, comma,
Result declared on 7/6/23. The results are also declared on 7/6/23.
and results were declared on 7/6/2023, comma, this the order dated 13/6/2023 passed in this writ petition, which stands partially modified
Yes.
in terms of order passed today in WBC 3609 of 2023, for which the order passed therein is kept as a part of record.
Possible only indicate it is in respect of only this particular society. There are 5 societies, my lord.
In respect of
Dakhin Boguribari Samabhay Samiti Limited.
in respect of Dakhin Bogoribari Samabhay Samiti Limited. Stand modified only in respect of this. Okay.
Obliged.
So may I
If you-
refer one thing, Honorable Lordship? Till registrar takes a decision, the approval shall not be given to the newly constituted board of directors of Dr. Bogoribari.
No, because the election dispute is already there. He can pass an order, interim order also. Because I can't give an interim order and then ask him to do it.
Yes.
He will find prejudiced. You can move the authority for that interim order.
Obliged.
Item 14.
May it please, Your Lord.
Yes.
Not that advance of the petitioner is there, but during the financial year 14-15, my lord, the petitioner, my lord, received payment against execution of certain works rendered to the railways, my lord. Now, as per the central government policy, my lord, any payment received from railways is exempted from service tax. The petitioner initially received a footnote notice from the assessing authority. Now the assessing authority initially holds that the petitioner is liable to pay service tax because on for the receipts, my lord, on the basis of certain income tax returns. My lord. The petitioner gives his explanations. The assessing authority is satisfied and he drops the assessments. Thereafter, my lord, may I just take your lordship to page 173. my lord. That a revision is done. In that revision, in the subject matter, my lord, where it is stated about the subject matter, my lord. The appeal filed by the department against OIO, that means order in original, my lord. Dated so and so, passed by the additional commissioner Central Excise Guwahati arising out of order in revision, my lord, OIR. In OIR proceedings, my lord, the petitioner was never served any notice, my lord. So he didn't have any occasion to appear there. And he could not, he was actually denied of his right of natural justice. My lord. Be that as it may, my lord, but when the notices of the appeal were served upon him, he appeared, my lord. He appeared and he tried to give his justification, my lord. That the payments that were received during that particular financial year were from the railways. Now, my lord, it is the case of the petitioner, my lord, that adequate opportunity was not given to him only when on one day in a very hurried manner, my lord, the matter was decided against him. If your lordship peruses the findings recorded by the authority, my lord, at page 201, my lord. And it is the same assessing authority who has filed the appeal, my lord. First he assesses, he gives a clean sheet. My lord, the same assessing authority, he files the appeal, my lord. First he, my lord, makes an assessment, is satisfied with the explanations given by the petitioner during assessment. Then he himself files an appeal, subject to some revisional proceedings to which, my lord, petitioner was not put to notice. And if your lordship wants to peruse the ground taken by the same person, my lord, it's very interesting at page 180, my lord, is his memo of appeal. The same person, or the same officer. 180, my lord, the very first paragraph. On examination of the aforesaid OIO passed by the additional commissioner, CGST and CX Guwahati, I being the reviewing authority, am of the opinion that the OIO does not appear to be legal. The same person, my lord. And at this stage, my simple prayer is there. If, my lord, the matter is remanded back and if I am given an opportunity to place all my records, my lord, I will satisfy the appellate authority that I have all the bills and vouchers and the bank statements, my lord, will establish. Because before your lordship also, I have produced the audited balance sheet, my lord, for that particular year. Bills, of course, I have not filed, my lord, because this will be very voluminous, my lord.
In this appellate order,
Lordship.
where is the reference to the origin order in revision? Where is that? Order in revision is something I missed out.
My lord, the
Is
appellate order,
193.
Huh?
193.
193.
revisional application, a revision application, lordship, in the very first paragraph. Under section 35E.
No, not that.
No.
This is only the what you call the.
Alternative remedy.
Huh?
With regard to alternative remedy available.
No. Page 193 is clearly that accompanying this, that you have these rights. No, not that. What is the original past in the, what is the order in appeal, revision?
Lordship.
My lord, may I just draw your lordship's attention to 195, my lord, the first paragraph of the appellate order. The appeal may read, my lord. The appeal has been filed by additional commissioner CGST and CX Guwahati, hereinafter referred to as the appellant, against the order in original number 11 additional so and so, hereinafter referred to as impugn order, passed by the same authority, my lord, additional commissioner so and so Guwahati, arising of the order in revision, dated so and so passed by the principal commissioner CGST, CX Guwahati, in case Messrs. Associates.
No, but what is the order passed in this order in revision?
My lord, we are not privy to this, my lord. We have not been signed it.
In this appellate order, there is no mention. Apart from this, there is no mention.
Yes, there is no mention of that. That is the departmental procedure laws.
So the SSC is not had.
No, Lordship, in this case, Lordship, after passing by the order by the assessing executing authority, the order was placed departmentally to the concerned authority. And they come to a conclusion that this order is required to be, appeal is required to be filed. That is a departmental procedure.
So the
Yes,
SSC is not had.
Hearing of assessing is not necessary in that case. When the appeal was filed, notice was issued to them. And they filed their objection to that also. I can produce the record of if you Lordship.
Produce it. In the meantime, don't take coercive action against him.
Sure.
But Mr. G. Rahul Lanet, counsel for the petitioner, and Mr. S.C. K.R. Lanet, standing counsel for the GST, appearing for all the respondents. Next para. The order in appeal what is the order?
The order in appeal is at page 192.
192.
It is page 120.
190, order in appeal dated 9/1/2023, passed in order in appeal, in appeal number 16/GHY capital A Commissioner COMMR ST GHY 2023 is assailed in this representation of the Article 226 of the Constitution of India. Amongst others, on the ground that the materials available before the assessing authority regarding payment received from the NF Railway was not at all considered. And it is also projected that all the payments received from NF Railway towards works contract are covered by mega exemption. What is it called? Mega exemption
notification.
Mega exemption notification. Next, issue notice motion reasonable in 4 weeks, requisite extra copies of the registration be served on the just you were saying about the morning about this maintainability.
Yes, maintainability.
Keeping the issue of maintainability open, issue notice of motion return in 4 weeks, because the extra copies of the registration be served on the departmental council within 2 days. Next, till the next date of listing, the respondent authorities shall not enforce the order in appeal dated 9/1/2023 referred above. Next, the petitioner shall produce a certified copy of this order before whom?
Additional commissioner laws.
Okay, before the additional commissioner, office of the commissioner, GST, and CE Commissionerate, Guwahati, within bracket respond number 5, to bring the order to the notice of the said authority.
Wedding Lordship
Next,
records
Acha. Uh, before that, the respondents had liberty either to file an affidavit in opposition or to produce records in support of their contention.
19,
Deeply obliged.
Yes, we passed yesterday's order.
Yes, some order is there.
What is the date petition? Do you remember the name?
Yes, petition number is 3625/2023,
3625/2023,
item number 18,
item 1818.
18.
Mr. N. Mandal, Mrs. M. Burman and Mrs. G. Hazarika. Same order.
Slight difference would be only in this case, my name is appeared in the CETA copy. In that case, my name was not appeared in the CETA copy.
Okay, just note the name of the petitioner appeared in the CETA. Okay, okay.
Deeply obliged.
Is election matter? Yes.
57,
Well, item number 22 to 26, can it be taken after?
Just a moment, I'm taking up from this 57, the election matter, I have to pass on, it's an assigned matter. Yes,
We have filed an IA in item number 57. Praying for the filing of written statement for 4 weeks. Possibly today I have gone through the petition. Possibly we'll also file an application that I am with a limited knowledge of my election laws, very limited knowledge, is barred by limitation. And as your lordship know, although it's
no, you go through the record, there's something, then you should go through it.
my lord,
Because it was filed, it was defective for quite a long time.
my lord,
And
that's why
therefore, you just see this.
I'll just say, about item number 16, let it be on item number on 18th, my lord. 60, they say another election. Another election petition is item number 60.
No, in this case, this item 77,
Yes,
this is connected with your matter.
Yes.
So we
77 is
grant you time for
My lord.
filing written statement.
If I can have the,
I am sending it to you, just a moment. Heard Mr. KP Pathak and the senior counsel, assisted by Mr. Ibarwa, counsel for the applicant, as well as Mr. D. Jaskar and the senior counsel, assisted by Mr. S. Hawk, counsel for the opposite party, who is the election petitioner in the connected election petition, next para. By filing this interlocutory application, the applicant who is the respondent in the connected election petition is seeking 4 weeks time to file affidavit in opposition. There is allowed matter stands at this interlocutory application stands allowed. In the election petition, you write, Mr. Didas, senior counsel for the petitioner, KV Pathak, appearing for the respondent, in view of the order passed today in connected IA Civil 1812 of 2023. 4 weeks time is granted to the respondent to file affidavit in written statement in the matter. Give a date after 4 weeks.
25/7,
damn reporter's report itself is in violation of chapter 8A of the Guwahati High Court rules.
No, then you can take it.
That I'll make a formal application.
So, which is the other matter?
Item 60. That is, we have filed at one IA for recalling of an order passed by lordship on order 7. Because we
Yes.
yes, that may be taken up on 18th as well. That is the hearing the item.
On
18th of
July. Okay, due to possibility time matter could not be taken up 18th of July. Mr. K. Pathak, senior counsel, Mr. A. Barua. Counsel. Yes, now,
Well, item number 47,
yes,
there's some urgency to be taken on Tuesday, my lord.
Tomorrow.
That no, tomorrow will be my lord, Saturday.
Oh, no, Tuesday. Okay,
Tuesday, my
okay, okay.
Monday listing may be difficult now.
Yes, Monday will be difficult. Okay,
Tuesday, I mean,
Tuesday.
item number 22-26, my lord. You also may said it after vacation, my lord, because we have already filed the affidavit. Mr. Central Government will file that
Item
22-26, my lord.
22 to 26.
Yes, ma'am. He will file the affidavit, ma'am. Central Government. I am applying for respondent number 4.
22 to 26. Responding of who?
And Mr. Chakraborty will appear 1 to 3, my lord. He will file that.
This with the possible matter could not be taken up today. It has been pointed that respondent of 4 has
Huh?
already filed affidavit in opposition. Mr.
All the item, all the item.
B. Chakravarti Ranil, CEC. Prays for some more time to file affidavit in opposition. Just after the ensuing vacation, summer vacation. I'm not fixing a date right now.
Not so can we fix a date, my lord.
I'm not fixing it because the problem is that after vacation, so many matters are coming. I will not be able to manage the board. Make a mention, then we'll see.
Yes.
There's an interim, my lord, that we can.
Interim order passed against and is extended to the next date of listing.
In all the matters.
Hmm?
In all the matters, there's an.
Okay,
This matter was not listed for long time.
I
mentioned this
understand.
matter.
I understand. You make a mention if it is not listed because I'm finding it difficult to manage the board immediately after vacation.
Lordship, with regard to item number 37, may it be taken up any day in the next week, Lordship. There is an urgency in the matter.
Item,
37, Lordship.
what is the matter about?
It is relating to settlement of fishery, Lordship.
Fishery is not very urgent.
Lordship, any day in the next week, Lordship.
Give it.
Any day. in the
Wednesday.
next week.
27 or 28, whatever. I'll take up Mr. Sheikh's matter.
Of like, Lordship, item number 72, 73 and 74, there's an interim order, Lordship.
Just tell the court master. I'll take up Mr. Sheikh's matter. This petitioner is 80 years old.
That please, Lord.
The government will be required here. Mrs. Baman
My lord, comment.
will be required here. Land acquisition.
My lord, the backdrop of the case is like this, my lord.
No, but
Our
appeal
resident-
I can't hear and dispose it of.
My lord. No, my lord, not hearing, your lordship would be pleased to see.
Huh.
One letter has been sent on 18/3/2023 by the deputy commissioner to the government, man, saying
Okay.
that compensation is ready only for opening of the passbook by the deputy commissioner. Permission is necessary by the government. And if the passbook is open, my lord, I will get the compensation. That is the block, my lord.
Where?
Already it is on record, my lord, that
Where?
order dated, that letter dated 18/3/2023.
18?
18/3/2023. Is necessary, my
Oh,
lord,
that
I-
will not be permitted. That will not be permitted.
Hello.
DDO is not permitted to open separate accounts. It goes into only one account.
My lord. No, my lord, only thing is this, my
Just a
lord.
moment.
Real, yes.
No, Ms. Hazarika,
Yes, sir.
this is something you will have to clarify. This is so far as I understand, any establishment, government establishment operates only in one bank account.
Lordship.
It can't have multiple bank accounts, correct? It is there in the Assam financial rules.
Lordship.
It's not permitted. So therefore, what is happening is that railway is ready to
Pay that.
transfer the compensation, but the deputy commissioner doesn't receive it. He will have to receive it in the general account and then transfer that money to the petitioner.
Lordship.
Can you have it clarified?
Chief, actually, regarding this, we have communicated with the department. The deputy commissioner is asking permission from the department.
But
to
that's not
opening a bank
permissible.
account also.
But that is not permissible.
Okay.
Under the financial rules, it's not permissible. That is why he can't open a bank account. He's writing to the government. Government will not give that permission because the financial rules prohibit that. So what will happen to Mr. Sheikh?
I'm 90 years old, my lord. My money 9 lakhs pending with this authority, my lord.
We'll obtain the insurance. and
No, in fact, what we'll say is that because those rules I have forgotten. This were read long back. I don't even remember when I read last. Some financial rules. That's right. I heard Mr. M.A. Sheikh, the counsel for the appellant, also heard
Accounts.
Ms.
May I please
Uh,
instruction, my lord?
Ms. Pamberman, and government advocate appearing for respondent number 1. And Ms. G. Hazarika, standing counsel for the revenue department appearing for respondent number 2.
This is from Deputy Commissioner to Railway Officer, my lord. In this regard, payment, he is requesting, taking the difficulty to payment should be made to the person concerned direction, my lord.
But the railways have responded, they can't do it. And they will not be able to do it because you see, the acquiring authority is the deputy commissioner. So therefore, he can't do it.
Just find only that much.
During the
But earlier, some compensation was given by the deputy commissioner.
during the pendency of this writ petition, sorry, this appeal, which is preferred against the judgment and award dated 4/2/2021 passed by the Runner District Judge Bongaigaon in PS within bracket LA, bracket close number 30 of 2016, it appears from the communication bearing number, last page, huh? Bearing number so and so dated 18/3/2023, that the Deputy Commissioner Bongaigaon is seeking permission from the Principal Secretary to the Government of Assam, Revenue and Disaster Management within bracket LR Department, permission to open bank account for land acquisition purposes, so as to collect money from the NF Railway, which they are offering to the which they are ready to pay as per the award of the decreed amount of rupees 9,29,040. Next paragraph. It is made to appear that the establishment of the Deputy Commissioner would not be permitted to open a second bank account in view of the financial rules. Yes? You're saying something? Under the Assam financial rules. So therefore, perhaps therefore, till date permission to open a bank account for land acquisition purpose has not been given by the competent authority. Next para. Under such situation, the court is inclined to observe that as the Deputy Commissioner Bangaigaon has an operational bank account, it would be permissible for the Deputy Commissioner Bangaigaon to receive decretal amount of rupees 9,29,040 from the NF Railway, which the said authorities are offering, and after the proceeds of the said account is credited to the bank account of the regular bank account of the Deputy Commissioner Bangaigaon, it would be permissible for the Deputy Commissioner Bangaigaon to issue a check or any other manner of e-remittance to remit the said decretal amount of rupees 9,29,040 to the petitioner, namely Saidur, Syedur Rahman.
Muhammad Saidur.
Mohammed Saidur Rahman. Next para. In this regard, the Deputy Commissioner, Bangaigaon, shall take note that on 27/5/2022, when the petitioner, when the appellant had shown an affidavit in support of the appeal, this appeal memo, he was 89 years of age, and therefore, by passage of 1 year, the appellant is now about 90 years of age. So therefore, the Deputy Commissioner Bangaigaon, within bracket respondent number 1, shall take urgent steps with the competent authorities of the NF Railway to have them remit the decretal amount of rupees 9,29,040 to the office of the Deputy Commissioner Bangaigaon, which shall be credited in the usual bank account of the said establishment and then transferred to the account of the petitioner by either by check, bank draft, or by other mode like RTGS, NEFT, etc., or online wire transfer, or online transfer of money, by whatever manner it deems fit and appropriate. Next para, the appellant shall produce a certified copy of the order before the Deputy Commissioner Bangaigaon to bring the order to the notice of the said authority so as to act upon the same.
May I pray for a time frame, my lord?
You'll do it. You see, they will now write back and get it back. You know the difficulties. That's why I've given your age to do it.
Some considerable time may be given, but the time frame.
No, I've said as expeditiously as possible. 89 and as expeditiously as possible.
Within a time of 3 months or 6 months or like this. Time may be a bit.
Preferably within a period of 2 months.
My lord. Much obliged. Much obliged.
Mrs. Hazarika, you have to tell the Deputy Commissioner, either you as a standing counsel for finance, for revenue, or Mrs. Burman, because you see, these rules I have read long back. I don't know, maybe 20-25 years back. It's for an establishment, just like a high court. There is one public account where these deposits come, which are public deposits. So, for example, you file an appeal, you have to give some security here.
Yes.
So that is or MSCT appeal. Some amounts are deposited here. it goes to a different account. Because it's not a institutional account. It is for the benefit of the parties. In Deputy Commissioner's office, I don't know. In District Judge office also, there's only one account. Where all money goes there.
Yes.
And from there, salary is also disbursed. From there, even other expenditures are made. So somebody has to tell him that this is to be done.
My lord, actually some amount earlier also paid for.
It's
separate,
okay,
not-
maybe
Not
this,
insisted for separate account.
no, maybe the Deputy Commissioner does not remember, he may not be guided well by his staff. Because you see, we do so many things, but I have got no occasion to go to the deputy, sorry, my accounts office and understand how they are handling things. We take things for granted. I have no business to go there and check out how my accounts office, how account section is working. So at times we face difficulties.
Lordship is closing.
No, only this, I'm not closing. This is an appeal. I can't do anything.
Lordship.
The appeal will listed after 4 weeks. Okay.
Declare.
Mr. Sheikh, this is an incorrect application. They have to withdraw this petition, 2680.
I am.
You have to withdraw it, because otherwise I'll have to recall my order.
Yes, my lord.
You know why I'm asking you to recall it? You are invoking section 54. Section 54 is execution. Now, what do you want?
Would do, my lord.
Yes, on instructions, Mr. M.A. Sheikh, counsel for the petitioner, seeks to withdraw this petition. The prayer is allowed, matter is dismissed on withdrawal.
Then this order will be passed in the main appeal.
Main application.
Yes, ma'am. Obligation.
Now then I have to send you back to the district judge for execution.
Fine.
Luckily my court master showed me this, otherwise it would have been an incorrect order.
Obligation, my lord.
মানুহ 10টা থেকে বহি যায় ওর শেষ কিন্তু কোনো নকৰে হ্যাঁ